Item 1, madam. Item 1, I have also informed my senior friend. Not today I am praying because my file is missed. Just not today only. My lord may take up any other.
Friday, kindly take up Friday. Friday.
Friday,
Any day, my lord.
as requested on behalf of the state, list this matter on Friday.
Next.
Item number 2.
Myself is the petitioner. Myself is the petitioner. As for amendment of my petition, yesterday I filed one I. Then please.
What is this matter about?
My prayer for submission of the fresh petition.
Why has this matter come before the division bench and the division matter?
It similar benefits under the R&R policy 2006 after land acquisition. That's why it's a division bench matter. My lord.
He is claiming compensation.
And this is not the assignment. The assignment is different. My lord, sir. I think, lordships, it's land acquisition. The bench, I think, as per the roster, your lordship's bench is not the assignment. My lord.
Accused. All right. It is stated by the petitioner in person that he has filed an application seeking amendment in the presented application of the said interlocutory application is not there on record. List this matter on 2 weeks with the interlocutory application on record.
Item number 3.
May I, lordship, please. My lord, in this matter, my lord was directed on 4th of this month to file a affidavit.
My lord was never directed. Yes.
Yes, we are today, my lord, we are filing the affidavit. This matter pertaining to, my lord, illegal transportation of iron ore, my lord. So today I am filing, my lord, the affidavit
Illegal transportation of iron ore from where?
from that one place of Odisha to Paradip port in different countries, my lord. And there is a CBI seeks permission from the state government to inquire in this matter, my lord, which is pending. And in the last occasion, my lord directed to file a affidavit in this regard.
What is CBI?
My lord,
What is CBI?
CBI investigation was
What is CBI?
Central Bureau of Investigation. Was.
Central Bureau of Investigation is what?
Is investigating agency, lordship.
Under which provision?
In the that is a central provision, my lord, central act based on the Delhi Police, my lord, Delhi Police Amendment Act.
Delhi Police.
Yes, my lord.
Whether the CBI has power to investigate.
My lord, when the interstate ramifications are there, that is why, my lord, CBI seeks permission from the state government to investigate this matter, my lord.
Yes. So when was the permission sought?
My lord,
When was the permission sought?
my lord, permission sought, but last occasion, my lord, directed to file the affidavit. Today, my lord, I am filing only this affidavit. Let matter answer to any day. We are ready to.
Which affidavit you are filing?
My lord, last time, my lord, you inquired about the petitioner's bona fide. That is what, my lord, I am filing.
You have filed.
Yes, my lord. Today, I am filing, my lord.
Today you are filing.
Yes, my lord.
And counsel for the petitioner states that pursuant to the court's direction, a supplementary affidavit is in the process of being filed today.
Yes, yes, ma'am. Can I file here or I'll file?
No, file
Yes, ma'am.
please.
I'll file.
Let it be done. This matter of
Item number 4.
Let them serve the copy also.
Yes, yes, I'm sorry.
copy
I'm sorry.
of the said
Right now, I'm
the
sorry.
affidavit be served upon the. Please don't give him. Give the.
In the
This process.
Registry-
Okay, madam.
in the
I'll
registry
file.
and-
I'll file. We'll file.
Then junior counsel assisting him. Why should you hand over a copy to the land advocate general?
I have not seen.
All right.
In my front, my lord, that's why I could not see.
All right.
Obliged.
The copies of the affidavit, copies of this affidavit have been served upon the Union of India and the state of Orissa. Served upon the council.
I am hearing for Port Trust, my lord, Paradip Port.
Port Trust.
For Union of India, they may serve another copy.
All right.
Yes.
Sir. So, list this matter on 1 week. Yes, Mr. Advocate General,
Yes,
what is your instruction?
my lord,
The CBI is seeking permission to investigate.
my lord, I did not want to tell your lordships, but kindly look at the brief. I don't think my learned friend is very much acquainted with the case. Kindly turn to page 138 of his petition.
Item number 3, है ना? Page number
138. What your lordships are told is that there is some illegal transportation of ore. Actually, the ship sank. And if your lordship sees page 139, paragraph 4, your lordships will see, my lord, this is regarding sinking of a vessel MV Black Rose. May I read it, my lords? In
Yes.
view of the above, the director so-and-so has sent a letter followed by so-and-so requesting therein for transfer of so-and-so relating to the incident of sinking vessel MV Black Rose. This was regarding sinking. Now kindly look at the next paragraph. In the alleged matter, the state police has already filed, my lordships have para 5, has
Yes.
already filed charge sheet under various sections of law, including cheating, forgery, keeping further investigation open. Moreover, the government of Orissa has not responded to the request of transfer of further investigation. So and so. Now, next line is very important. Further, the Paradip port, where it sank, has denied any misconduct on the part of its employee, and therefore it would not be possible for CBI to register and investigate a fresh case under the provisions of the PC Act, for which previous approval of the competent authority or PPT would also be required for investigation against public servant. In view of the above, reference to so-and-so is allowed to rest. My lordships have it. Last
Yes.
paragraph. My lords have para 6. In
Yes.
view of the above, it is intimated that the forwarded reference of Ministry of Shipping enclosing representations of trustees of PPT and annexures is allowed to rest with the approval of the competent authority of CBI. Further, CBI would take so-and-so. So therefore, they have rested it. So it's not a case of illegal transportation from one state to another or one country to another. It's a case of a sinking ship.
No, it is not that the CBI is making any request for transfer.
Right.
Rather, it simply says that if the government wants
Correct.
any
Fair
further
enough.
investigation,
Fair enough.
after submission of charge sheet, then the CBI is ready to take up that investigation.
And then
Yes,
they
sir.
finally say, because Paradip port itself is now saying,
So the transaction is of 2009
I'm grateful.
and we are
And
in
this person has
2024.
not even filed a complaint anywhere. He is not filed. Your lordship knows.
We will hear it.
My lord, can I pray, my lord?
We will hear you, we will pass appropriate.
Yes,
orders.
ma'am. I'm obliged.
Be ready for that.
Yes, ma'am.
Item number 4.
Item 4, my lord, I am for the respondent. Today I have received the appeal memo, my lord. I pray 15 days time to file this objection.
Huh?
I am for the respondent, my lord. Today I have
Yes.
received the appeal memo. I pray for time. 10 days time, please.
And counsel for the respondent. Respondent
My lord.
seeks adjournment to consider the writ appeal, a copy of which has been served upon him, received by him recently. So as requested, list this matter on when?
At least 15 days.
15th,
My lord, 15.
2 weeks. 2 weeks.
Item number 5.
Reminder matter relating to admission in the nursing course, my lord. Batch of case your lordship in WBC number 1482 2024.
So that is judgment is
Judge,
reserved.
my lord, after disposal of list this matter after
List this matter on 2 weeks.
Item 6.
Permitted to withdraw, my lord.
Withdraw.
Item number 7.
Hello, item number 7, pass over the matter.
As requested on behalf of the petitioner, list this matter on 1 week.
Item number 8.
I may please your lordship, my lord. I am not well. I pray let it come Friday or Monday, any day, my lord. I'm running through fever, therefore I'm praying before lordship. I'm not prepared in the brief.
1 week
Item 9.
as requested.
May I please your lordship. This is a content matter, your lordship. I may permitted to VC, your lordship. Your lordship's order dated 10th August 2023. Lordship are direct to consider. This is related to payment of escalation amount. Lordship please to directing the opposite party to dispose of the representation by the petitioner, my lord. That is a time period was given 3 months, my lord. And the order was passed, your lordship, 10th August 2022, your lordship. It has not been complied, your lordship.
Not complied.
Not complied.
I will obtain instruction notes because it said representation only. Lordship grant me 3 weeks time. In the meantime, I will see that it's complied with me.
See, in 2 litigations,
Yes.
nothing could happen. In the writ petition, there was simple direction for disposal of the representation.
No,
Thereafter, there is a contempt
no,
petition.
this is first contempt, Lordship.
First contempt, this is the contempt. What is
Yeah.
first contempt and second contempt?
Exactly, Lordship. It was
Is
not.
there any provision under the rules for the second contempt?
No. No, I said that must have been completed. I will obtain instruction because there was a direction in.
2 weeks' time is allowed
Yes.
for the contemners to call on counsel for the contemners to seek instructions and inform this court as to whether this court's order has been complied with or not.
Orders item 10.
Item 10, my lords, that's a remand from the Honorable Supreme Court. Well, sir, may I pray, my lords, I have contacted my client because he has sent all these records and briefs to the Supreme Court lawyer, not got back that. Honorable Supreme Court has remanded the matter for hearing of the matter. I pray, my lords, 2 weeks time so that I can.
So where is the order?
That's order was on 12th February 2024, my lords. So that is the order, my lords. I downloaded it from net yesterday itself and I contacted my client.
Delay is condoned and.
Delay condoned and the matter is remanded.
Restored. That was
If I remember correctly, my lords, because that's an old matter, all similarly situated persons are covered, but the petition can't come in time. That is why it was dismissed for default. Then thereafter, I filed a petition, my lords, for restoration, and it was rejected on the ground of delay. That is what the petitioner preferred SLP before the Honorable Supreme Court, and ultimately, my lords, the remand, my lords. It's a covered matter, in fact, my lords.
I will also, my lord, in the meantime, an order has been passed. I will take instruction on 21/10/2008. My humble submission to this honorable court will be to rendering it infructuous. Maybe it has been brought to the notice of the honorable court or not. I will also examine.
Render infructuous.
21/10/2008.
Unless this matter on 2 weeks, stop. Let in the meanwhile, learn counsel for the petitioner and the estate seek instructions as regards the status of the petitioner's case.
Item number 11.
I was fixing it, my lords.
But there is delay in filing the appeal, my lord, and delays during the COVID period, my lord. And not a signature the path on 3rd of March 2020, and thereafter COVID period started, and during the persisting COVID period, I have filed the appeal. So entire delay during the COVID period, I pray that same may kindly be continued.
So when did you file?
My lord,
31/3/21.
yes, ma'am. 31st March 2021.
Wow, but then it is covered by that, the Supreme Court's order.
Well,
Supreme Court order. Okay.
but here, my lord, state is not a part.
Huh?
State is not part. It is the Chief Manager, Indian Bank. But my lord's question, that delay period is covered.
So the entire period is during
My
COVID,
lord.
and 10/1/22
Ma'am.
order is also covering that.
Ma'am.
The appeal is not treated as time barred. Stop. Let it be placed for admission. It is not for admission. Admission for order. Who is for the other side?
I'm there.
You don't have any, then counsel for the bank does not have any objection to.
Your Lordship may say it is within the COVID period.
Objection for listing this appeal for admission on.
Yes, Lord, admission, yes. Copy has to, notice has to go.
Serve a copy.
Yes, I will solve the copy. Notice
Take-
has already
take
gone.
notice.
On that.
Notice limitation matters, Lord, notice admin issue.
You can take notice in the main matter also. All right, let it come. Let it come.
Yes,
for
yes,
admission.
let it come.
We'll see then.
Item number 13.
My lord, sir, may I be permitted now?
Yes,
Item 12, my lords, are fixed at 2 p.m.
2 p.m.
2 p.m. Item 12. So, my friend is also here. My lord, actually, we are preparing an affidavit. We'll be filing it in course of the day, ma'am. It's getting ready, ma'am. Today only. So, my friend is here. If my lords, I will serve the copy and I will file it before my lord's registry by tomorrow. Today I will serve him copy.
Which item?
So,
So let that be taken up at 2. Make the mention what you are
Ma'am.
making mention at 2, so that all the parties are here.
fair.
Other councils are also there. He is not there.
Mr.
No.
Sharma.
I am item 2 and
Mahendra Mahapatra.
some people are not there.
We will see.
Ma'am.
Item number 13.
Item number 13, my lords, that Utkal University before my lords in appeal. Utkal University before my lords in appeal, my lords. Utkal University, one of the premier institution of the educational institution of the state, my lords. My lords, challenging the direction of the honorable single bench, regularizing service of the petitioners, those who admittedly joined after this Umadevi case, my lords, the cut of that fixed, my lords. There is a delay of 220 days, my lords. That is what I've stated, my lords, at the region that NAC team visited, and there was some amount of delay, my lords, in this part, my lords. That is what I've explained. I received an objection from the side of the respondent, my lords, director, that I received the objection. They said that all the records were very much available and you could have, it could have been filed and the delay cannot be condoned, my lords, because it is not prevented by any sufficient reason. Well, my humble contention twofold, my lords. One is there is a delay, but 220 days, my lords. And that too, I have stated the regions, my lords, so far that NAC team visiting, my lords, knows that the NAC team is a very important aspect so far that the university is concerned and all the
What is
departments,
this thing?
my lords. NAC team, my lords, are giving NAC A, NAC B, NAC C, that is what they say that gradation of the universities throughout India, my lords.
Therefore, you could not
My
file
lords,
your
that
appeal.
all these were busy, that is what one of the region and the old record pertaining to 1997 concerning read petition, some of the records could not be ascertained. That is why there is a delay. I have stated that. Now, my lords, that is my first ground. My humble contention, my lords, before my lords, about, I think, my lords, conscious of the position of the legal position that laid on by the Supreme Court. If there is a ground, there is a region, and that region must touch the very root of the case and it can decide the merit of the case and it involves a point of law, then the condonation of delay or the region of delay should not stand as a ground, my lords.
So we should consider the ground first before dealing with the limitation.
That exactly, that is what I've stated, my lords, for the first, at the first ground I've said about the region of delay and I've said about the region, then the second region.
But you have exploited them first.
No.
You have exploited them first.
No, but first ground in my lords that the 220 days delay, and I said that NAC team visiting and other regions, and that is why there is a delay. That is what we have explained in the petition. or whatever I explained in the petition, that is my ground, that so far that sufficient reason. The second is, my lords knows about the position of the law, my lords, that yes, if there is a delay and the case involves a point of law to be considered, this aspect also can be considered. And in a case also from our Honorable High Court.
Group D employees, you have exploited their.
No, question of Group D employee, my lord. They were appointed after the cut-off date passed by Uma Devi under the in different hostels, my lords, and that too they require regularization pursuant to a decision of the Honorable High Court confirmed in Honorable Supreme Court in the year 1997 concerning other employees, and that was limited to 78 persons and creating supernumerary posts, my lords. Whether these benefit can be extended to the petitioners on the basis of the principle laid down by Honorable Uma Devi case, my lords. Honorable Supreme Court in Uma Devi case, my lords. That's one aspect. In the meanwhile, my lords, 2-3 decisions have come where, my lords, Honorable Supreme Court said no regularization unless and until it is against the regular vacancies, and if it is a contractual appointment, there cannot be a regularization.
Mr. There is one principle.
My lords.
That if any of your statements in the limitation petition is found to be incorrect, false, then your application will deserve to be dismissed on
that is my lords, that I can, that is the peaceful, my lords, whatever my lords says.
If you want, I can.
Bow down, my lords, that what my lords says, that I bow down.
Difficult. While matter is stood thus, while staff of the concerned section were required to find old records concerning the present dispute, then the registrar retired from service so and so after attaining the age of superannuation. What kind of explanation is this? So the controller of finance was in charge, but he remained awfully busy being.
May I submit, my lords, on these things, my lords?
What is this?
May I submit, my lords? It is
and what old records? The entire writ petition was when you were contesting the writ
petition. Is not that, my question is that the writ petition, my lords, a kind of glance to the judgment.
Sorry.
Well, kind of a glance to the judgment first.
Why should we?
No, why I said that the relevant documents which required, old records were required, because the judgment referred to decision rendered decision concerning 1997. Some document concerning that.
So is this your submission that the learned single judge has taken into account certain documents which were not there before the court?
Some of the documents are not there before the court, even particularly date of
review.
But particularly,
you can file a review then. If this is your case, that the learned single judge has taken into account certain documents which were not there on record, file review. Let's see, these are the documents which were not there, still you consider. And what you are submitting is beyond imagination.
Would I request?
Just give us an example. Which document learned single judge has relied upon which was not there on record? One example.
Would my request, my lords?
What?
Thing is that, my lords, the very important thing is the date of joining of the date of joining of the particular petitioner.
Yes.
Whether before that date, the judgment was implemented or after. That particular was in fact was not disclosed, nor document relied upon and has been decided. Now I'm not on there. If my lords will permit me, because it is an university, my lords, I'm defending that.
No, the university and state and union.
I'm submitting it.
Are immaterial.
I understood, my lords. I'm submitting that. If my lords will permit me, I will give an affidavit in detail, explaining the detail of the sequence for my lords' consideration.
We'll be happy. Give it. But you may be inviting trouble also.
Whatever, my lords.
For the appellant, I have stated that the statements made in the application, in this application seeking condonation of delay, vaguely referred to the reasons for delay in preferring the appeal. So stop. He seeks adjournment to submit before this court the date-wise movement of the file after receipt of the order under appeal, whereafter a decision was taken to prefer the present appeal and was subsequently filed on.
The writ petition was filed on 5/9/2023.
The
writ appeal.
5/9. 23. For the said purpose, list this appeal on 2 weeks. Yes.
Item number 14.
Against the order dated, sir. Against the order. Order of the learned civil dated.
Item 14.
My lord, there is a delay of 242 days in filing the writ appeal. This is for fresh admission it has come. If my lord will be pleased to grant me to take notice on limitation, and if my lord will permit me, I will place it on merits.
No, limitation, why should we condone?
My lord, 242 days is pension matter. I'm aware of it. And only thing is, my submission is the judgment relied upon by the Honorable Single Judge is contrary, ma'am. I can demonstrate, my lord, here. The judgment relied upon by the Honorable Single Judge that the case of the petitioner is, writ petitioner is covered. My humble submission to this Honorable Court, the judgment relied upon speaks contrary. Para 19, if I can read.
No, but what is your explanation?
242 days, my lord, that is it. The judgment relied upon by Honorable Single Judge is contrary, in fact. Basing on which the relief has been granted. My lord, no Subarna Dibya. Para 19. Here the petitioner has died in 70. 70 he died. Pension scheme came in 81, 86. And the Honorable Single Judge said that had he continued in service, he would have continued up to 97. Then
both the matters. Both the matters.
My lord, I am appearing for the respondents.
Let him serve copies on both IA as well as the
In this
main
case,
case.
the
To
government
file
filed-
objection and as well as.
My government filed
I
an
will-
undertaking that we will comply, then file this writ application. That's why 242 days delay. In third contempt, when we have filed contempt, first contempt, then second contempt, then there is a personal appearance in third contempt, then my lord, they have filed.
We will deal with them.
My lord.
Just
So they let them solve a copy.
issue notice to the respondent. MS, what's your name, madam?
My name is Saswati Mahapatra.
Accepts notice on behalf of the respondent. Let requisite number of copies of the limitation petition as well as the memo of appeal be served upon her in course of the day.
my lord.
Stop. List the matter under appropriate heading on 2 weeks.
My lord.
For admission, item 15.
May I say one thing, my lord? My lord, may permit us to comply the order subject to this writ appeal. We'll comply the order. Subject to writ appeal.
It will be open for the estate to comply with the order of one single judge, which is under challenge, subject to final outcome of the present appeal.
15.
Yes.
This was heard by your lordship from that day. Lordship were about to dictate the order after the lordship recess.
Yes.
The 2 p.m. matter was taken up, so this was orders could not be delivered in the.
So let us recapitulate. What was the matter about?
Matter, Millets, it's a matter where a deity's property of a temple.
Oh, yes.
That was put to auction. Millets, I was a participant in that auction. And Millets,
we remember now.
Sir, only one thing, just Millets, one decision that is Chenchurami Reddy, which has been followed also in 2021. Let's may I submit one paragraph.
Yes, yes.
That's what is my concern for lordship. The deity, the entire thing will hold with the deity's loss. So it was not.
You can file a suit. You can file a suit. It is not that we are deciding the list.
My lords,
The last paragraph, that's para 10. That's the law Millards also relied upon in 2021 in his judgment. Plus, if I can demonstrate before your lordships that the entire thing was in a clandestine manner and so clandestine.
Please.
Plus, we cannot conclude. Plus, we cannot conclude without observing that property of such institutional endowments must be jealously protected. It must be protected for a large segment of the community has a beneficial interest in it. The authorities exercising powers under the Act must not only be most alert and vigilant in such matters, but also show awareness of the ways of the present day world as to the ugly realities of the world today. They cannot afford to take things at their face value or make a less than a closest best attention approach to guard against all pitfalls. The approving authority must be aware that in such matters, the trustees or persons authorized to sell by private negotiations can in a given case enter into a secret or invisible understanding with purchasers at the cost of the concerned institution. Those who are willing to purchase. Here in a case, if I cannot demonstrate your lordships, this particular, that what is that extraordinary circumstances appearing in this case, that I am here before your lordships in a read jurisdiction, then I may not, I may be out by the court. But here the circumstances that is total in this entire things is available, Millards. It's a case.
So in this case also there was public auction.
There was an auction by way of negotiation. This case is here. What has happened in this case? If I would have been allowed, the matter would have been finished. They didn't allow me to participate, even though my offer was submitted. The circumstances that I have to narrate in so within 5 minutes, if your lordship allows, I can tell you what is the fact about why I am concerned, why I am before your lordships.
No, you are there because you were not allowed to participate. So your interest, private interest.
Millards, the deity's property is to be protected.
Again, if we are repeating the same thing, you are not interested in the deity's property. You are interested in you acquiring that property.
But the price, ultimately the
price you can give. If you are if you believe in charity, you can give that much amount to some charity.
The property that has been sold among the blood relations, that is what 456. That is, and I was not allowed.
All right.
May I just raise the case for 5 minutes, your lordship. If I will not channel, your lordship will.
Section 19 petition was allowed.
Section 19 was allowed. Allowed. Allowed with a price of 25 lakhs.
No. Whatever price.
Thereafter,
we are not concerned. Whether that property was allowed to be sold.
Allowed to be sold.
By allowing Section 19 petition.
Section 19 petition carried in an appeal. Then the price was reduced and it was put to auction to face the best price. Then at that point of time, they wanted to sell it within themselves. Then when I got the information, I put my, it was not accepted. Then I went to the additional assistant commissioner by the due date. He accepted my bid, and thereafter he asked me to appear on the date of the negotiation. I appeared. There, Your Lordship, I will show that how I was rejected, because the trustee who is to seek best fresh price, he opposed my presence in the negotiation. What they did ultimately the manager, hereditary trustee, sold the entire property to his brother, Millard's opposite party number 6, and ultimately who in turn saying that I have purchased this property for 34% by way of a manager. Your Lordship may see the at page, that's the affidavit of the endowment additional assistant endowment commissioner, page 135 of Your Lordship's running bill. Had there would have been auction, this property would have been gone at a very high price, Millards. 135 of the running bill. (133) it starts the affidavit, and 134 is the relevant paragraph. Is 134, Your Lordship, that the affidavit filed by the additional assistant commissioner of the endowments, that it is pertinent to mention here that on 24/12/1998 at about 4 p.m., Samasundar Mahapatra, the petitioner, came to the office of this deponent and requested him to receive an envelope and a letter addressed to the additional assistant commissioner of endowments. In due course of business, this deponent received the letter on 24/12/1998. That was the last date of the bid, because at 4 p.m. And the said letter along with the envelope was diaried on the same day, bearing diary number such and such. This deponent also directed that the letter should be put up on the date of negotiation. It is further humbly submitted before the receiving the letter, this deponent directed the petitioner to go to deliver the envelope to the power of attorney holder of the heritage trustee. The petitioner, however, intimated that he has already gone to the temple, but when the heritage trustee was found absent. On this, he asked me, he received the bank draft and the entire offer in a sealed cover, which has to be opened, and thereafter a negotiation. That is what it was to be received by hand. That is what I was saying, that 5 minutes will give a very clear picture how the endowment property was sold. Your Lordship may come to page 210. Sorry, 201. Running page 2. That's the order by which I was after accepting, and who opposed my another applicant. Your Lordship got it. Page 201, running page. That's the order of the additional assistant commissioner. Order dated 26/12/1998, passed by additional assistant commissioner. Another participant, namely Sri Samasundar Mahapatra, appears and submits that he is also interested to participate in the negotiation. He admits to have submitted his offer directly in the office on 24/12/90, showing that he could not find the hereditary trustee in the institution. It's a fact that he submitted his application, etc., as per the terms and conditions, but in this office instead of to the hereditary trustee. As per the terms and conditions, here the ST has given power to one Arup Kumar Panda to do the needful in his absence, power of attorney holder. Hereditary was not available. He has given a power of attorney to. It seems to me that Sri Mahapatra ignorant about this fact and has filed this paper in this office. This matter is discussed with the power of attorney holder, who is the heritage trustee working ST in detail. He raises objection to allow Sri Mahapatra to participate in the negotiation since he has not acted upon as per the terms and conditions. In the circumstances of the case, after due discussion with the Orissa, I am not inclined to accept the submissions of Sri Mahapatra to allow him to participate in the negotiation. Hence, the prayer of Sri Mahapatra is rejected. Hence, his application, shield cover, along with the bank drafts of 1 lakh, be returned to him purposely. I was not then, it was settled with question. Your Lordship may see who opposed my presence, who would have been accepted that the best price of the should come. My participation was prevented because once I could participate or any public, then it could not have been settled with the opposite party number 6, who is the brother of opposite party number heritage trust. That is what my millards, they prevented me only for the purpose that you can. Then your Lordships, what transpired on the day of auction? Let's page 119. That is the how it is settled. The power of attorney holder, your Lordship got it. The power of attorney holder of ST, Sri Arup Kumar Panda, is present with 3 offer letters. Another interested man is Samasundar Mahapatra, who has submitted his application with required draft on 24/12/1998. That was the last date of auction. With a request to allow him to participate in the negotiation is present. He has shown a ground that he could not find the ST in Cuttack and has filed this application directly in this office. 3 persons who have offered their applications to the ST as per the terms and are present. Prayer of Sri S.S. Mahapatra is rejected as per the orders in separate sheets, which I read, your Lordships. Negotiation was taken up as per separate sheet between 3 persons. 2 of them, did not offer and more amount. The third man, namely Ashwini Kumar Panda, agreed to offer more, and he told to purchase the case land rupees 15,17,000 per acre. Hence, his offer to purchase the case land is agreed rate is accepted. He just other 2 didn't participated, and he says that I will pay 15 lakhs, which was basically the negotiation sheet is attached separately. He submits the earnest money of 1 lakh in the shape of 2 total amount case lands agreed at 38 lakhs such and such. As per the terms and conditions, Ashwini Panda is directed to deposit 1/4 of the total price of the case lands comes to such and such. This is what I want to demonstrate for Lordships. Then, Millards, your Lordship may come to page 201. Sorry. Right. That is my gender. That's 193, page 193. It is humbly submitted, para 10. It is humbly submitted. Opposite party number 5 is the brother-in-law of opposite party number 4, in favor of whom opposite party number 5, the power of attorney stated to have been executed by opposite party number 4. And as such, the opposite party number 5 is the brother of opposite party number 6. The clandestine, illegal, and unprecedented sale has taken place since the opposite party number 5 is the brother of opposite party number 6, and both of them, in fraud collusion with the opposite party number 4, made a systematic attempt to grab away the property for the institution in order to show the unlawful favor. This is what my submissions before your lordships. That is why I started saying that it's an endowment property. Because my participation and repetition, it must get the highest price. That is, even in 2021, that is the law. That whenever a property, religious endowment property, because people involved, it must be allowed to the fair auction, or so that the best possible price can be made. And here is the case. They didn't receive my negotiation sheet. Then other persons were not there. I was prevented to participate after receiving the thing. If I would have participated, what would have happened? I would have been allowed to contest. It would have gone more price, and the ultimate beneficiary would have been the deity, the temple. Here in case, I shown your lordship that the hereditary trustee himself opposed my participation. And it would have been a case that any other bidders otherwise, because they were not interested. They just opened, they said, we are not going to enhance our price. Opposite party number 6, he enhanced. Another thing, after this, when the process was over, one thing is very surprising. I shown to your lordship that the order sheet says that one Arup Panda participated as in the bidder and he was selected. But later they say that 34 persons, he was appearing on behalf of 34 persons by virtue of a power of attorney in respect of the land. This is what my submission before your lordship, that it's a case where interventions should be made, and your lordships should allow the property to be put to public auction press, so that inviting a wide publicity. That's one. This is what basic challenge to this application is this, that since it's an endowment property and I wanted to participate, and who other than, that is why I showed to your lordship that it happens. Because whenever somebody in a trust, in the property of a temple or something, they want to grab. This is a normal, sometimes it is invisibly they do. Here in this case, this has happened. And I have participated in the tender. Admittedly, in the it was there was a the page 19 116, that is the tender terms and conditions. It clearly speaks that it has to be interested bidder buyer shall have to submit the offer in a sealed envelope addressed to the hereditary managing trustee, Sri Siddheswara Mahadev, Siddheswara Saikatta, either by hand or by registered post. The offer should carry the earnest money of 1 lakh, the demanded from in favor of the institution, Sri Siddheswara Mahadev, in any of the nationalized bank. Offer should reach the hereditary managing trustee on or before 5 p.m. 24/12/1998. On the day, your lordship may say the very notice in the latter part. Here in the notice, there is nothing that power of attorney holder. Now, this is the document filed by them. They say that in hand, your lordship may see. They say that we have written that Arup Kumar Panda, power of attorney holder, this only. They say that you must, somebody must understand from there that you should not go to the heritage trust who is available on the day of auction or before that. You should have gone to the. So I was because I wanted to participate in the auction if there is a property of a deity. I want to participate and I have gone. The judicial officer of the state has participated. What was wrong? Not allowing me, Lordships. And Lords, with this, I think there is no disputed question of facts as of Lords. It is my participation. There is nothing. It's not a case that I have not. Only thing, Lords, in the auction also it was not there that somebody has to purchase the paper because it was to be presented in a plain paper. Again, Your Lordship, I am reading that the bid has to be put in a plain paper. Not that somebody has to purchase something and thereafter. Now they say that this particular thing was not purchased. It was never a condition anywhere that it in a plain paper, you have to submit your affair along with 1 lakh draft. So that once it is open, then it will be allowed to party to go for negotiation. But to whoever will be the best price, he will be paid. That is why.
Have you completed?
Millards.
Yes, anything?
I am appearing for 4 and 5. Opinion number 4 and 5. But with due respect, let me clarify the position. At present, all the property that was sold in public auction in presence of the Assistant Commissioner of Endowment, because he was supervising the sale, 42 persons have purchased. All of them have constructed their house over it. After this 98 matter, interim order was there initially that was vacated subsequently after the interveners appeared and filed an application for vacation of stay. And all of them have constructed the house, as was my information. But here the disputed question is, my friend says it's not a disputed question of fact. He is a man from Chhatrapur. The bank draft, if Your Lordship looks at, has been done at Chhatrapur, which is about 120 kilometers away from Cuttack. As per the public notice, signed by the power of attorney holder, his address is given and his details given, telephone number given. But he has published the notice that you must file your offer with the bank draft by 5 o'clock on a particular day. The last day itself, 24th. He did not come and file. The terms and conditions says, approved by the Assistant Commissioner, that you have to file it within the times prescribed. He did not file it within time. And he goes to the Assistant Commissioner's office at Bhubaneswar, not at Cuttack, and files his application. That Assistant Commissioner kept it on record saying, you are supposed to file it before the hereditary trustee or the person who has been authorized, not here. So it will be considered on the date of when it will be considered by the authorities. So in 26, when the matter was taken up for consideration, he found that it has not been filed before the hereditary trustee, even though terms and conditions says that. Therefore, it has not been accepted. It was objected not because he is to participate, objected that he has not approached or filed his bid within the time as per the terms and conditions. That was the objection. And therefore, whoever participated, but this is a case where 3 times the public auction was directed, 3 times it failed because nobody came forward. The law minister, the legal law department intervened. Subsequently, a date has been fixed and the Assistant Commissioner fixed the date with terms and conditions. It is not that the hereditary trustee does anything. Section 19 permission was granted, and as per law, the procedure has been followed, and the auction has been held, and eventually the negotiation was done. There is no illegality or irregularity in the procedure. But now he says I have been deprived because he didn't approach. He didn't came on the particular date. But if Your Lordship looks at that his application at 4 o'clock, the counter of OP number 1 and 2, they are the public officials, Commissioner and Assistant Commissioner. And look at the counter. At 4 p.m., he goes to the Bhubaneswar office, files the document. 4 p.m. Cuttack is again here for half an hour. He could have come here. But on the same day, at 4:45 p.m., as per the counter, other persons approached and filed their bid. 4:45. He was still in the office till 5 o'clock, till the time was over. These are the questions. If he has agreed, he should have filed the suit. Prove all these factual aspects. But he is approached in the court bona fidely.
That's all.
Well, only thing, I have submitted at number, not at.
Six, I have appeared for OP number 6. May be permitted. Kindly see, I have filed a small counter, I have stated at page 29 of the brief, that is the relevant portion. And only place the relevant paragraphs for your lordship's appreciation. Why it will be discussed. The lordship got it, para 4. I'm sorry. Page 29, para 4. My lords, the lordship may I just place it. Yes. The writ application is liable to be dismissed with exemplary cost for making deliberate false, inconsistent, unbearable, and untenable statements by filing an incomplete annexure 2. The reasons for dismissal are stated below. 1. Petitioner admittedly has not purchased the approved notice in annexure 2 on payment of ₹10. He also does not disclose from which original notice he filed the alleged true copy of annexure 2, which has been filed deliberately omitting the order of approval of the opposite part number 2 and the endorsement of opposite part number 5 as power of attorney of opposite part number 4, who is stationed at Delhi. Xerox copy of the approved copy of the annexure 2 with seal of the opposite part number 2 was sold to 42 intending bidders, out of whom only 3 bidders came for negotiation. Xerox copy of the real annexure 2 is filed annexure A by 6. The lordship will come to page 35. The lower person, he has not filed this thing to show it has been delegated to power of attorney, and the assistant commissioner has told you give it before the power of attorney. And all the option has been made in the presence of the government officer, assistant commissioner. Secondly, minor, petition has not filed. On 24/12/98 was the last day of submitting seal tender. The power of attorney of opposite part number 5 remained present in the office of the opposite part number 4 till 5 p.m. on that date. So the false plea that the petitioner did not find opposite part number 4 in his office is not only inconsistent but also false. Annexure 3 shows that the demand draft was obtained from Indian Bank at Chhatrapur, district Ganjam. It is not disclosed as to why he obtained the same on the last date from Chhatrapur Bank. He gives his address from Cuttack. He stays at Cuttack in the writ petition. Opposite part number 6 on bona fide inquiry came to know the petitioner is not at all solvent for payment of even offset price of 15 lakhs. He has been set up by real estate dealer of Chhatrapur to file the offer before opposite part number 2. Opposite part number 6 filed his offer for self as well as power of attorney of 35 others as per application of opposite part number 4 on 24/12/98 with enclosures disclosing the intending purchasers, including institutions, advocates, retired employees, and other middle-income group persons. Xerox copy has been filed. The allegation of fraud and collusion of opposite part number 5 and 6 is false and vague. Then one important factor, my lord, may come to para 5. Considering for the sake of argument, his offer that the quotation of other 2 bidders were 15.02 lakhs and 15.5 lakhs. And opposite part number 6 quotation, who has taken the bid, was 15.07 lakhs. And by negotiation, the price had been increased to 15.17 lakhs. And all the money, what as per the endowment procedure 19, has been kept in fixed deposit. Because that is the law, the fixed deposit is the endowment commissioner. So by negotiation, it has been, and the petitioner offer is 15.05 lakhs. So if he would have participated in the bidder, he is 15.05, but the opposite part number bid, that was considering for sake of argument, the who has taken auction was 15.707, and by negotiation also it was increased to 15.17 lakhs. Therefore, the auction has been, and I have written the amounts. Your lordship may come to page para 6, page 32. Have all the opposite part number 4 and 5 already received from opposite part number 6 a sum of 19 lakhs owned, out of which 14,95,000 have been kept in fixed deposit in the name of the DT placed to opposite part number 1 in 99. That is the endowment commissioner. The balance amount is kept in savings bank account of the trustee for this fixed deposit for demarcation of the land. So absolutely no illegal process, and this is a disputed thing. He has never come to the office to submit the bid in time. Therefore, the petition should be dismissed. That's.
Can I lead to just one document? Can I show you one document from the record? Page 114, my lord. Page 114. The public notice that was given for public auction. But this, it contains the terms and conditions fixed by the Assistant Commissioner, which is at page 116. At page 116, it specifically provides the details which are to be done. Paragraph 5, it says, interested buyers shall have to submit offer in sealed envelope addressed to the Heritage Trust Managing Trustee, Sri Siddheswar Mahadev Siddheswar Sai, either by hand or by registered post. The offer should carry an earnest money of 1 lakh from the demand draft done in favor of the institution in any of the nationalized bank. The offer should reach the Heritage Managing Trustee on or before 5 p.m. on 24/12/1998. The offer should be submitted in a plain paper giving detailed name and address of the intending purchaser. Earnest money deposit consideration amount shall be paid and time schedule so and so. But the signature has been made by Arun Kumar Panda, the Heritage Trustee. Details has been given in both the pages. He says, I did not know who is Arun Kumar Panda. I did not know who is the power of attorney holder. Therefore, I submitted before the commissioner's office. But it is he came to know from this advertisement. It is there, signature is there, everything is detail mentioned in the bottom of it.
You have not filed it.
He did not file it, my lord.
Meeting this, you have filed.
He has suppressed the document. But he knew about it. He could have easily filed it if you would have a genuine person to participate. The only grievance is participation.
The only thing that the statement made that I have deposited at Bhubaneswar, it's not a correct. The affidavit itself of the additional assistant commissioner from Cuttack is from Cuttack. I have submitted at Cuttack, not at Bhubaneswar, because I didn't.
Sorry, I'm extremely sorry. I'm sorry. Cuttack Assistant Commissioner Office.
Cuttack. And let's, as far as that, why I went there, let's, if I have already made a draft, they are questioning how you get the draft, who paid the money, this. But the managing trustee is interested in the best price of the property that is being, we are as a trustee, we are selling the property. That in the entire process, no third party has participated except your lordship. They said that my offer was, yes, my offer was this, but it was not that the final. Then a negotiation would have been held. In the negotiation, there would have been a competition. It would have reached to any price. So let's, but this here is a case which have prevented people altogether.
Have you completed? Yes. Tomorrow for the judgment. No.
Item 16.
Just a minute.
My lord, in this case, the order passed by the Central Administrative Tribunal is under challenge, where my lord, the Permanent Tribunal has said that even though the petitioner has resigned, he should get pension. And our objection was because he tendered his resignation and which was accepted and he was relieved. So as per Rule 26(1) of the CCS pension rules, the past service is forfeited.
Yes. Where is the order of the tribunal? Where is the order of the tribunal?
My lord, Annex 3.
Annex 3.
2-3 date. Page 30. Page 36, ma'am.
No, when did he resign?
My lord.
Did he resign?
Yes, my lord.
When?
On 5/12/1981.
5/12/1981.
Yes. He joined in 1971 and resigned in 5/12/1981. And by that time, he says that he has completed 10 years of service, so he is entitled to pension. Our objection was that since he resigned and for getting a better job elsewhere, and his resignation was accepted and he was relieved, so as per Rule 26(1), the past service.
The matter was heard earlier.
Yes, it was heard extensively, and my friend was has taken time on that day to submit more.
What?
Lordship, sir, rule that today will be the petition will be disposed.
My lord already noted it in the order.
You approached 18 years after. You approached 18 years after.
Yes, 18 years after. And he stated that after resignation, he got a state government job, and there also he retired and he is getting pension. It was contended.
Which rule is that?
26. CCS pension, CCS pension rule.
Central Civil Service.
Central Civil Service pension rule 1972.
What rule?
Rule 26, man. Forfeiture of service on resignation.
And you were bad informed.
Service or a post unless it is allowed to be withdrawn in the public interest by the appointing authority entails forfeiture of the past service. This is clause 26(1). 2 says a resignation shall not entail forfeiture of past service if it has been submitted to take up with proper permission another appointment, whether temporary or permanent, under the government where service qualifies. So here in this case, my lord, the opposite party tendered resignation, and in the application he has said for getting job elsewhere. That is his case before the yes, without permission.
The document, which is the document?
My lord, he has already. I have annexed the copy of the original application to the writ application. Your lordship may annex 1 series, running page 18 of the writ application. It starts.
Annexure page 18.
Page 18, my lord. The original application which was filed before the Learned Tribunal. And the relevant portion, my lord, by narrating the facts before the Learned Tribunal, he has stated
No, resignation letter is there.
Where is
he
the
is not annexed.
resignation letter?
He is not annexed, my lord.
No, you must have.
That is there, my lord. He has stated there. It is humbly submitted in order to be appointed elsewhere the better job. The petitioner submitted resignation, and pursuant to his resignation letter, the petitioner relieved on 6/12/1981 by letter dated such and such. A copy of the such letter is annexure 2.
But Annexure 3, which Annexure 3, page 28.
That is his representation, my lord.
Yes.
Subsequently, yes.
Yes, that is the only document which
That
he
is
has
the only, yes,
controlled.
yes, yes.
Annexure 3, where is your resignation letter, mister?
I only have the appointment letter and the relieving.
Do you have the resignation letter on record? Rule 26 will apply in your case or not?
Lordship, I am relying upon Rule 26(7) and Rule 37. That's with technical resignation.
And you have admitted that page 28, Annexure 3, which was part of OA. I had submitted my resignation and I was relieved by SDO Telegraph Jutney, wide memo number such and such, dated such and such.
Before that, in the OA, I have stated that.
But you say that you are specifying the memo number and all, but you have not enclosed the document. You are not showing it also.
This is the last representation. A para below that, I have stated that I have said.
Yes, you have stated memo number and dated. In specific terms, you are stating that this is the memo and this is the date on which, by virtue of which you have been relieved. So you are not enclosing that document. And you claim that you don't have that document. How could you say this?
But I filed the case after 18 years of the delay. I joined in 71 and retired.
All right, you are relying on which sub rule of section rule 26?
Rule 26(2) and 26(7).
Rule 26(7).
7.
How 26(7) will apply?
Rule 37 will comment.
No?
Rule 26(7) says, our resignations submitted for the purpose of Rule 37 shall not entail forfeiture of past services under the government.
No, Rule 26, sub-rule 7.
Sub-rule 7.
We have that. Seven.
7.
But 7 was not there when your resignation was accepted.
Lordship.
Why are you relying on this?
For that, I am relying 26(2) also. Lordship.
Just a minute. Whether rule 7 will, sub-rule 7 will apply in your case or not?
Lordship, Rule 26(2) actually will apply to my case.
First answer this question. Whether sub-rule 7 will apply in your case or not. We want this answer from you.
Exactly, rule, no, Your Lordship.
It shall not apply. Say that. Even if something goes against you, you should be fair enough to accept. Why shall that not apply? 1991, that was not in force when you had submitted your resignation. So you should not have placed reliance on that. All right. We also at times get, we will not say misled, but confused.
Lordship, on last occasion, I have stated that I am relying only upon 26(2).
26(2).
And the memorandum system.
Just a minute. So for relying on 26(2), you were required to establish that you had taken permission. 1 and 2 in the department. You joined somewhere else. That will not apply. It's a simple case, I think. Petitioner in the present rate application has put to challenge an order of the Central Administrative Tribunal, Cuttack, Bhubaneswar, passed in OA number order dated 27/8/2003, passed in OA number 678 of 1999. Stop. The facts of the case are short, which is relevant for the or present adjudication. So stop. This is Union of India has filed it.
My lord.
Union of India has filed the text. The facts of the case relevant for present adjudication are short and not at all in dispute. So stop. Opposite party number 1 was working where? Under telecommunications. What is that?
Astral, my lord, Astral Post and Telegraph Department, because postal and telegraph were at that time. Subsequently, it was bifurcated.
Sir, please. Sir.
He joined in the Astral Post and Telegraph Department. But by the time he retired from BSNL.
Was appointed as repeater
Station assistant.
Station assistant in the Post and Telegraph Department, which was subsequently bifurcated and was redesignated as the Department of Telecommunication. Stop. The petitioner, the opposite party continued as such till 15/12/1981, when he submitted his resignation, consequent upon which he was relieved by the subdivisional officer bracketed telegraph, Jatni, bracket closed, while memo number C36/59 dated 5/12/1981. Stop. The opposite party 81. Next. 18 years after he was relieved, consequent upon his resignation, he filed the said OA number so and so before the central CAT Cuttack, seeking Cuttack, claiming that he was entitled to pension from the petitioners as he had completed a requisite number of years, requisite completed 10 years of
More than 10 years.
qualify more than 10 years of service qualifying for pension. Full stop. The tribunal, by the impugned order, has allowed the application filed by the opposite party, which is under challenge in the present writ application. Full stop. Next. Learned your CGC or what?
But I am appearing for BSNL.
Learned counsel for the BSNL, so and so, which is the successor organization of the employer of opposite of the telecommunication department, has submitted that in view of section rule 26, submitted that sub rule 1 of rule 26 of the civil services, central civil service pension rules, in most unambiguous terms, provides that resignation from a service or a post would entail forfeiture of past service. Full stop. He submits that by operation of sub rule 1 of rule 26, the service of opposite party number 1 for the purpose of grant of pension stood forfeited as he had resigned from service. First stop. Next. Learned counsel appearing on behalf of, he has also argued that 18 years after he was relieved from the post, he approached the tribunal for claiming pension, which ought not to have been entertained. Stop. Next. Learned counsel representing the opposite party has, on the other hand, relied on sub rule 2 and sub rule 7 of rule 26 to contain that the tribunal has rightly allowed the petitioner pension for the period he had served under the transmission department. What is that? Telecom department for more than 10 years. Stop. Next. In our considered view, sub rule 7 of rule 26 shall have no application in the present case, as the said rule was inserted
Set subrule. Set subrule 7. Set subrule was inserted on 9/10/1991, comma nearly 10 years after the after opposite party number after acceptance of resignation of opposite party number of the opposite party. Full stop. The petitioners, the case of opposite party number one, of the opposite party, that he had joined government service. Which service?
State government.
That he had joined state government service after resignation, and therefore his case would be covered by Rule 37 of the CCS pension rules is untenable for the reason that the said rule shall apply only if the same is read with sub-rule 7 of Rule 26 of the rules. Full stop. We have already noted that sub-rule 7 of Rule 26 shall have no application in the present case. Full stop. Next. The contention on behalf of the opposite party that sub-rule 2 of Rule 26 of CCS pension rules shall apply, has rightly been applied by the tribunal, comma, is also not acceptable to this court. Sub-rule 1 and sub-rule 2 of Rule 26 of CCS pension rules read thus. Stop. There are two on bare reading. There are two on bare reading of sub-rule 2 of Rule 26. It can be easily discerned that there are two prerequisites, two preconditions to apply sub-rule 2 of Rule 26 of the CCS pension rules. So stop. Firstly, comma, the resignation is for the purpose to take up another appointment under the government where the service qualifies, and two, with prior permission to take up such appointment. So stop. The opposite party did not bring on record his resignation letter either before the tribunal or in the present rate proceeding. So stop. there is absolutely no material on record to suggest that the petitioner had sought any permission to take up appointment under the government, a requisite for under the government, so as to apply sub-rule 2 of Rule 26 of the rules. So stop. It is pertinent also to mention that the government under sub-rule that the government stands defined. Where is the definition?
There's
Government.
my lord. Page 20 of the detail, please.
Just a minute. Government has been defined under Rule 3 bracketed I of the CCS pension rules, which means central government. So stop. In such view of the matter, in such view of the matter, comma, the submission of the opposite party that sub-rule 2 of section 26 shall apply cannot be accepted. So stop. Consequently, we accordingly hold that by operation of sub-rule 1 of Rule 26 of the CCS pension rules, the service of opposite party rendered in the Department of Telecommunication stood forfeited for the purpose of grant of pension consequent upon his resignation without any permission to take up an employment under a government को quote unquote, within the meaning of Rule 3 bracketed I of the said rules. Stop. Accordingly, this writ application deserves to be allowed, and the impugned order passed by the tribunal set aside. Stop. Consequently, order dated so and so, right? Application is allowed. We are conscious of the fact that the opposite party had approached the tribunal 18 years after his resignation was accepted. There is no dispute that in the case of, in that present case, CCS pension rules 19 Central Civil Service Pension Rule 1972. 1972.
Filed an affidavit on 25th 9 to 2023, my lord. That is not on record. That may be called for, my lord.
Just now the regender affidavit. Let him next week. I am for the opposite party one of sole opposite party.
What
And
is this
today I
matter?
am filing the region.
Huh? This is 19 years old matter.
Yes, my lord.
What is this matter about?
The compassionate appointment.
That's not appointment.
Yes,
B, compassionate appointment.
So who are you?
We are coming against the order passed by the tribunal, my lord. Where the heirs, my lord.
What the tribunal has done?
Tribunal has passed and disposed of the OA, my lord. Under annexure, my lord 3. Page 43, my lord. Thereafter, under annexure 3 at page 43, my lord. And my place, my lord.
So what is the, come to paragraph 3 of our last order.
Last order.
Yes,
So whether he has,
4324, we have.
you
passed one order.
directed to.
Para 3, you.
Yes.
Please come to para 3 of that.
Lordship directed to take instruction regarding the age of attaining the age of superannuation, my lord. And he has not attained the age of superannuation.
so whether you are working somewhere.
Your Lordship, as per their regender, I just now received the regender. The date of birth is 12/3/1969.
So he knows your date of birth.
I submitted the certificate before the authority.
Sir, you should have said that this is my date of birth.
Lordship.
And we had put two questions. One, that whether you have attained the age of superannuation. You, in fact, yourself had mentioned that you attained the age of superannuation. And two, whether you are engaged otherwise somewhere else.
No, I am. No engagement.
Have you stated?
I have not
you
stated.
filed any affidavit?
No, my lord.
Have you received instructions?
Till that I have not engaged. On the 2022 notice was served upon me in this matter. 2005 stay was there, but they have not attempt regarding their issuance notice served of the notice. After 15 years, notice was issued to the opposite party. Thereafter, I appear and
no, help. But the fact remains that you are not engaged.
Not engaged.
Not engaged.
Not engaged. To that, your Lordship file an affidavit.
And he must be doing somewhere.
Labor class. Nowhere.
Nowhere.
No here.
Then how is he living?
Now is
livelihood. Somewhere he must be eking out his livelihood.
We are considering compassionate appointment.
Your Lordship.
When did his father die? The father or who? Father?
Father was died.
When did he die?
90. Died on
16/9/1990.
95.
90. 69. 1990.
After 34 years, what purpose will it serve?
After attending the age measure, they have applied for the post. That is right.
Court also, my lord, dismissed, allowed a writ application by WPC number 3595 of 2007, which was filed by the Union of India, my lord. I have filed this in shape of an affidavit. That is not there on the record, my lord. I have filed that order, copy of the order, my lord. On 25/9/2023.
What is there in that affidavit? It is stated by learned counsel for the petitioner that a supplementary affidavit has been filed.
Yes, sir. On 25/9/2023.
On 25/9/2023, which is there not there on record. Post Office submits that the contents of the said supplementary affidavit are relevant for due adjudication of the present dispute. Stop. This matter on 1 week with the said supplementary affidavit on record, if found to have been filed. Stop. In the meanwhile, learned counsel for the opposite party shall be required to file an affidavit as to whether the opposite party is engaged, was engaged somewhere else after was in employment, was under employment in the meanwhile. All right.
Today I am filing the rejoinder and I have already served the.
File it in the registry.
Served the copy.
Do whatever you need. Do it.
Item number 18, public.
Please also. Because this writ application has been preferred by the state laws, challenging the award passed by the your labor court laws, where the workman opposite party has been directed to be reinstated in service on the ground that the termination was bad and section 25A of the ID Act was not followed by the authorities. Because kindly come to straight away the annexer once it is at page 9 millions. Page 9, claim statement by the workmen opposite party members. Lordship, schedule of reference. That was the reference made by the state government laws. Whether the termination of service of Sri Udayanath Raut NMR, workman by the executive engineer RWSN division Baleshwar with effect from 1/9/2002 is legal and or justified. If not, what relief Raut is entitled to. Then one lordship submission that the second party workman Sri Udayanath Raut was refused his employment by the first party management with effect from such and such date. It will also come to the entire pleadings. Nowhere he stated when he was employed, and how he was employed.
No, this is a reference made by the government.
No, it's claim statement.
No.
It's a quoting of the schedule of reference. If you also come to page 9, claim statement filed by the party workmen. Nomenclature.
We will not be governed by the nomenclature.
No.
We will see the body.
This is the schedule only. The schedule of reference made by the state government was quoted by the workmen. Thereafter, he narrates. Because also see prayer. Next page, page 10. Because this is the claim statement made by the workmen. Prayer is that the second part, the workmen, next page, page 10, before the Honorable Court, to kindly consider the above claim and pass award in favor of the workman along with restated service. His signature. This is the claim statement.
This is not the claim statement. This cannot be the claim statement. It's a part of what might have been mentioned. Otherwise, it's a schedule of reference only. Just see what is there. That the government of Odisha, Department of Labor, by so and so referred the dispute under section 10 of the for adjudication by the Honorable Court, and then schedule of references there.
Right.
So that is reference only.
Well, let's come to the.
So, Mahanti, is it not your claim statement?
This is the claim statement, but
Is it-
whatever my
is it your
learned
claim?
friend is referring.
Mr. Mahanti, what he says that it is your claim statement. Is it correct?
Yes.
Is it correct?
This is a claim statement.
This is impossible. This is impossible. This cannot be claim statement. Bring the original records.
Schedule of reference.
Whether this is claim or statement.
Are you at page 9?
I am at page 9, at one extra one.
Page 9 and 10. Right?
9 and
Whether
10.
this document, as Mr. Samantraya says, is the claim statement of the workman. Is it true? You are representing workman, no?
I am representing the workman. Yes, ma'am.
This is claim statement.
This is claim, but it is not. This is a claim statement.
This is impossible, simply. We would like to see the records.
Yes, call for the.
Huh?
Because it's a court. Personal call for the records from the court below.
Let it be called for, madam. May I submit, madam? So far, the schedule of reference is concerned. It is very much available on page 90.
Where is your claim? Where did you say that you were appointed, then you were illegally trained?
By way of evidence, it has been stated.
Oral evidence, then the reference could not have been made.
No, reference was there, madam.
Wrongly reference made then. The reference itself was bad.
No, reference was quoted in page 19. And have a glance to Annexure 2 is the award.
That is award.
Yes, madam. Now that has been quoted, madam. Because under the idea, a person cannot straightway approach to the authority. There is a system that I have to raise my dispute before the conciliation officer. On failure of the conciliation report, then it will be submitted to government. Under section 10, it will be referred to the government, and government will refer to the authority for the adjudication of the dispute. That exactly has been quoted in Annexure 2.
When will the government refer
exactly. That is available at page 19 for a moment. Annexure 2.
That we have seen, that is what this has been quoted from what we were seeing.
Yes, exactly.
Your claim of statement.
Yes.
A statement of claim.
Statement of claim. The exact verbatim that has been quoted there.
They have quoted the reference. So there is difference between the reference and the statement of claim.
Statement difference.
And where is your statement of claim?
That LCR be called for me.
Call for the records. Let the petitioner. Who will produce?
So because it's a court note.
Opposite party.
Call for the records to the registry only not.
Let call for the records of the industrial dispute case number 48 of 2004. 3 weeks.
From the PO Labor Code Bhubaneswar. From the PO Labor Code Bhubaneswar.
Industrial, sorry, from Labor Court Bhubaneswar. This dispute case number. Yes.
Item 19.
Until last occasion, you have right to the government to file counter.
Yes, Lord. Here it's they challenge the virus of section 7 capital A of the OGLS Act. Lord, we are pleased to direct me to Lord, file my response to this petition. Because I only pray can it be taken up on Friday, Lord. When even I don't find Lord, I respond to lawsuits only because it's a point of law only, Lord. If a lawsuit can take it up on Friday, I can respond to it.
No, we will adjourn it for Friday, but we are very unhappy about this situation that we are taking up 2013 applications.
Right.
has requested on behalf of the state this matter on 1 week.
Item 20.
That interim order is there in that matter.
Interim order
Previous
has not been
previous matter.
Item number 20.
May I please, Your Lordship? Your Lordship, if I may be permitted to refresh the case, Your Lordship.
You must.
Your Lordship, the petitioner was appointed as the assistant additional section teacher in the year 1990 as per the yardstick and qualification that was prevalent in that time. Thereafter, in 1993, an amendment was made to the rules as per which B.Ed and CT training was made mandatory as an eligibility criteria. Your Lordship, thereafter, the petitioner got approval from the government, however, was terminated 2 years later. Your Lordship, on the last occasion, I was relying on the judgment of Vivekananda Das, and my learned senior had referred another citation stating that the Vivekananda's judgment was either distinguished or overruled. However, even if my learned senior had referred to a particular citation, he has served a different case law.
Please give the dates again. I just missed to take note of your.
Yes, sir. Your Lordship, the petitioner was appointed as assistant teacher on 30/10/1990, Your Lordship.
90.
Yes, Your Lordship. 30/10/1990.
Yes.
The amendment came in 18/12/1993.
When date?
18/12/1993.
What was the amendment?
The amendment stated that CT training or B.Ed training was prescribed qualification.
CT.
CT.
What is CT training?
Certificate teachers training. Certificate course. After matric.
Yes.
And B.Ed.
Training as prescribed qualification to be appointed as assistant teacher or section teacher.
Yes.
Thereafter, the government approved the post of additional section teacher with effect from 7/6/1994. And in 1998, the appointment of petitioner was approved.
Yes. Yes.
Your Lordship, I am relying on the judgment of Vivekananda Das that I had placed on the last occasion, in which paragraph 5, Your Lordship.
So when did you acquire this qualification of CT? You were not required.
No, Your Lordship.
According to you, you are not required
Yes,
because
Your
you were appointed in 1990.
Yes, Your Lordship. And as per the judgment that I had relied upon, which categorically stated that during the relevant time, an untrained graduate teacher was eligible to be appointed as an assistant teacher in a non-government aided high school. He was not eligible to receive trained scale of pay. Untrained scale of pay, however, was admissible to him. The applicant being a pre-1993 appointee, his appointment cannot
Your
be...
appointment was on regular basis. This
yeah.
appointment in 1990 was on regular basis.
Yes, Your
Or
Lordship.
there was some condition.
No, Your Lordship. No
The
condition.
managing committee appointed.
Yes, Your Lordship.
When was it approved?
In 1998, Your Lordship.
By the government.
The post was approved in 95 and my appointment was approved in 1998.
On the date when managing committee appointed you in 1990, there was no post.
No, Your Lordship.
Post was created in 95.
No, Your Lordship, government took over the non-aided schools in 94, Your Lordship.
No, but is this correct that when you were appointed in 1990, there was no post available?
No, Your Lordship. In 1981, managing committee decided to open class 8 and additional section teacher taking into consideration. Yes, Your Lordship, there was a post. In 1981, the post was created by the managing committee, Your Lordship. And when I was appointed, this prescribed qualification was not prevalent.
So when was the institute taken over?
Yes, Your Lordship, taken over by the government.
When?
In 16/12/1994, Your Lordship.
So what are the terms of taking over? What are the terms?
Page 13. Page 13.
Page 13.
So your right will depend on that? The terms of the scheme for taking over?
My right, Your Lordship.
Yes.
Yes, Your Lordship.
Where is that?
Page 13, Your Lordship, as my Lordship rightly pointed out.
Page 13 is the scheme.
It's the resolution.
It's a resolution.
Yes.
All right. I could not get that. Page 13, 1-3.
Yes, Your Lordship. Page 13, Annexure 2 of the writ petition.
Just a No, but this is not the scheme. The scheme is there in 24/6/1994.
In 94, your post was not approved. The condition of taking over is you resolve to hand over the management along with approved teaching and non-teaching staff.
Yes, Your
including
Lordship.
assistants. So on that date, your post was not approved
Not
by the
approved,
government.
Your Lordship. Later, Your Lordship, in Annexure 3 series, Your Lordship may find wherein my post was approved. Annexure 3 series. April 29th, 95, Your Lordship. In page 17, my name can be found, Your Lordship.
Post approved on
29th April 1995.
5.
who approved?
Government.
Government, Your Lordship. Deputy Secretary.
Government in school. School and mass education.
So there is no dispute about that.
No, Your Lordship. This is an admitted fact, Your Lordship. Your Lordship, my submission is that once my post was approved, Your Lordship, there was a precondition that I had to obtain B.Ed or CT within 2 years, to which I have challenged in this writ petition, Your Lordship, stating that as per the law settled by this honorable court, I was not supposed to go through any kind of training if I am to be treated as an untrained employee, Your Lordship.
No, you cannot depend upon any law settled prior to coming into force the rules.
No, Your Lordship, it was settled after, whenever just like similarly placed employees challenged the same. It was settled in a case in the year 2001, Your Lordship. After the last time. Your Lordship, on the last occasion I had
And miscellaneous case number 2. Yes, what is there?
Your Lordship, in paragraph 5.
Paragraph 5.
Yes, Your Lordship. Lordship, during the relevant time, an untrained graduate teacher was eligible to be appointed as an assistant teacher in a non-government aided high school. He was not eligible to receive trained
Reading
graduates.
from Vivekananda.
Yes, Your Lordship. He was not eligible to receive trained graduate scale of pay. Untrained graduate scale of pay, however, was admissible to him. The applicant being a pre-1993 appointee, his appointment cannot be disapproved merely because he does not possess the training qualification. Your Lordship.
No, where is this order? OJC number 1012 of 1996. Because in Vivekananda's, what was decided in that case has been quoted.
Yes, Your Lordship. Your Lordship, this is also Vivekanand case wherein a miscellaneous application was filed, wherein the same proposition was reiterated, Your Lordship.
No, but here you are challenging the validity of rule.
No, Your Lordship. I am challenging the termination order, Your Lordship.
Yes. He is relying on the case of Vivekananda.
Yes, ma'am, I will come to that. Ma'am. Before that, I will bring to my lord's notice only that approval letter. Let's me turn to my counter filed here, my lord. In that counter, I have annexed that counter filed before the state administrative tribunal.
A/3.
A/3.
Page 40.
Yes, ma'am. It's the approval letter, my lord. Let's me. You'll also see the date, that the date is 12/6/98. Page, my 40.
Counter affidavit.
My lord.
What is there?
In that counter affidavit, I have annexed the counter filed before the state administrative tribunal. In that counter, I have annexed that is approval letter, my lord. Your lordship can find it A/3 of
Office order 8506.
Yes,
dated,
yes, my lord.
June.
My lord.
1998.
90. May I read, my lord? In pursuance of GO number so and so dated 29/4/1995, GO number so and so SME dated 31/7/96, read with director letter number 9783 dated 22/2/1993, and without prejudice to the claim of others, the appointment of the following trained
public untrained additional section teachers made by the concerned managing committee of the said schools noted against each are hereby approved with effect from 7/6/1994 in the prescribed scale of pay as detailed below. The next line is very important, my lord. They should acquire BEd training within 2 years from the date of issue of the order, failing which approval will be cancelled automatically. And your lordship can find it name. Yes.
You say that this approval is conditional.
Yes, approval is conditional. And his name finds place at serial number 3 K Pradhan, Kabi Pradhan. Then my lordship may turn to the.
So whether this was challenged?
I am coming. No, that was not challenged. That I am coming.
But
he challenged.
As it seems from the table, serial against serial number 3.
My lord.
K Pradhan.
K Pradhan.
Your date of approval is 7/6/1994.
That is
the date of taking over.
Because that was the taken over. Unless we approve him with the term of 7/6/94 as per the condition stipulated in that notification, we cannot take service to the government fold, my lord. So we approved him with effect from 7/6/94 and this order was not challenged. But he challenged, my lord, Annexure 6, page 21.
Annexure
6, my lord, page 21.
Yes.
Because he has not acquired that BEd qualification within 2 years, they are terminated. In our counter, we have taken a stand. He was sent for undergoing BEd training in the year 2000, but he did not avail that opportunity. So he was terminated from his service because he could not avail that BEd training. My learned friend has relied upon the decision of the Vivekanand Das case.
But let us understand.
And this
what is the
Yes.
This may be your case, and we don't know how strong is your case, that by virtue of this office order, since the writ petitioner could not obtain the qualification of BEd or trained teacher, the approval, the post got disapproved, or approval stood withdrawn. So what is the effect of withdrawal of approval?
Because that was a conditional of the approval. Sorry, I could not follow.
What is the consequence of withdrawal of approval?
That he will not get aid from the government. He will be an employee of the private management. He will not, because we are giving aid. Once the post is approved, government will extend the aid. Once his post approval is not there, he will get aid salary from his management.
Your condition was they should acquire BEd training within 2 years from the date of issuance of this order.
Yes.
Failing which approval will be cancelled automatically.
Yes.
Approval only will be cancelled.
Approval will be cancelled.
School is already taken over.
School is taken over.
There is no private management now.
Yes, ma'am.
So therefore, we want to know what is the consequence of cancellation of approval.
Yes, ma'am. You also have seen that the resolution at Annexure 2, the resolution says only the government will take over the approved staffs. Once that is not approved, government will not take over the employees.
So that is the moot question.
Yes, ma'am. You also have seen that Annexure 2, that is the resolution of the government.
Subject you say that, is it your case that by virtue of taking over, you have taken over approved or and non-approved? Both you have taken. Non-approved staff were given condition to satisfy the condition. In absence of that, the approval being withdrawn or cancelled, she or he would go back to that position prior to taking over.
Yes, yes.
There is no question of, see, it's a question of approval of appointment. It is not approval of a post. This office order talks of approval of appointment. All right. So these persons were appointed. This is what the office order says. And the office order approves their appointment by this office order. But this approval is subject to them acquiring the qualification. And if they don't acquire the qualification, consequence is prescribed that this approval shall stand cancelled. So approval of appointment stands cancelled by operation of this office order. Undertaking.
My lord.
Where is the undertaking?
Approval.
No, please come to the resolution.
Yes.
Annexure 2.
Just 10 lines from the top, the first paragraph. Non-government aided high schools, page 13.
Yes.
First paragraph, sixth line. The non-government aid and have furnished a written consent of each such staff. That is, do you have that?
No, that school must have submitted that before taken over. They must have submitted that. Unless they submit that, school will not be taken over.
Yes, where is the undertaking, madam? Have you seen that?
Yes, Your Lordship, of consent from the
Yes.
staff, Your Lordship. Your Lordship, I have no instruction regarding.
No instruction.
So there the undertaking must be that you should comply with the condition of approval.
See, your post was approved. Your appointment was approved
Yes, Your Lordship.
by that resolution.
Yes, Your Lordship.
But that approval was subject to certain condition. You did not fulfill that condition. Then how can you claim?
Your Lordship, I am submitting that such condition as per the judgment that I've relied upon should not apply to me since I was appointed with due procedure as was prevalent at that time in 1990 before the condition came into force, Your Lordship. The only question is, Your Lordship, if the required qualification can be applied retrospectively or not, Your Lordship.
There is no question of retrospectivity. See, you were appointed
Yes, Your Lordship.
in a private organization. The state government took a decision to take over such institutions and to take over the liabilities also, assets also. The teachers are assets, there is no doubt about that. But that was subject to certain conditions. Their appointments, the way, the background, the procedure which was adopted for their appointment, that was not gone into by the government at the time of taking over. And therefore, they put this condition that all right, in whatever manner you were appointed, if you later obtain this qualification, your appointment shall be approved. So that the policy appears to be reasonable. Let us see what is there in this decision now. Come to paragraph 5
Yes, sir.
of that decision. I don't think this will have. And unless we know about, we see that decision.
And also, I am relaying another judgment of this honorable court that Vivekanand Das has been taken into account, that it
No, no, let her come to paragraph 5. You are relying on paragraph 5.
Yes, Your Lordship.
The Roman 1 says during the relevant time, an untrained teacher was eligible to be appointed as an assistant teacher in a non-government, and he was not able to receive trained graduate scale of pay. So your appointment has not been cancelled on the ground that at the time of your appointment, you did not have the B.Ed qualification or training qualification. That is not the ground. The ground is that despite the clause in the office order that you must obtain B.Ed qualification, since you did not, therefore, your appointment has been cancelled.
Yes, Your Lordship. To that, my submission is that since I was appointed prior to 1993, the same could
The
not
most
be applied.
basic question is whether any untrained teacher can be allowed to continue as a teacher. That is most fundamental thing. And therefore, you were given an opportunity to obtain that qualification, which you did not. That is the question. So if there is no question of grant of scale of untrained or something, now it is the requirement that you must have that qualification unless otherwise you cannot teach. That is the reason. Yes, what is there? Let us see.
That is 99
2011.
99, no, sorry, madam, I am sorry to that effect. On last occasion, I have given the decision that 2011. So that is regarding that section teacher, that is not applicable. I have also given a copy of this judgment when it, to my learned friend also I have given that copy of that judgment, my lord. That 99 185.
Stand there.
On the same.
You complete bottom.
Nine 185. I have given that downloaded copy. This has been decided why an untrained teacher cannot be approved against 10 posts.
And even without these decisions, madam, find it very difficult based on the office orders.
Your Lordship, regarding not acquiring B.Ed qualification, also I have submitted in my rejoinder that when I was in full-time service, I was given 2 years to obtain, and as my learned senior submitted that an opportunity was given to me by the department itself, Your Lordship. To that effect, I have submitted that I had applied for the same, which was acknowledged. However, no action was, I did not receive any correspondence to that effect. As a result, I failed. I had given my try, Your Lordship. I had attempted to get my B.Ed qualification. However, due to the time limit, and Your Lordship, every judgment says that a reasonable time should be given to obtain B.Ed qualification. Because of this and because of the non-cooperation from the state itself.
No, B.Ed, you are not compulsorily required to have B.Ed qualification. They also provide some kind of training. The state government must be providing you something.
Yes, Your Lordship. That very training, Your Lordship, they purported to have given, wherein I applied and an acknowledgement was given to me. However, no such course was initiated or neither I heard back from them regarding the same. And in the meanwhile, while I was waiting for the feedback, the response, Your Lordship, I was terminated from the service. That also I have.
When were you terminated? When were your services were terminated? You cannot be terminated.
Services were terminated in 2021, Your Lordship.
In 2001.
No, so 2001. Okay, apologies.
2001.
Your Lordship, may kindly turn to my rejoinder. Page 5, Your Lordship.
Yes. Annexure?
Annexure 8, Your Lordship, page 5.
Annexure 8?
Yes, Your Lordship. The rejoinder. It is the copy of the acknowledgement, and the next page is the postal receipt that I received after I had applied for the course, Your Lordship.
Very difficult when your appointment was approved in 1998. This formality in 1998, June 1998, your appointment was approved, subject to condition. Now in August 2000, according to your own stand, for the first time, you approach them
to go for this qualification, B.Ed qualification?
Your Lordship, my learned senior had also submitted on the last occasion that was the time 2021, the opportunity was being given to the employees, Your Lordship, untrained employees. And that is since at that time, the petitioner was already continuing as an approved employee. The employee, Your Lordship, the petitioner applied for the post.
All right. Tomorrow. Anything?
No, my lord. This is the case. Your Lordship.
This is the case what?
I have given that judgment, my lord, that subsequent judgment had taken care of that Vivekananda's case and
Manmohan
Tripathi. Taking into account that 81 yardstick which prescribed the TGT qualification.
And in that, if I may submit, Your Lordship, in that judgment that my senior has referred, if Your Lordship may go through the last paragraph, the very petitioner was also given another chance to take up the qualification of B.Ed.
Now you have been out of service for 20 years.
I admit, Your Lordship, I'm simply referring to that.
All right, tomorrow.
Obliged, Your Lordship.
My lord, the affidavit is being made ready now. It will be, the affidavit is being prepared now. In course of the day, it will be ready. By tomorrow, I will file it and I will serve copies on Learned counsel.
It is, yes. It is stated by learned AGA that counter affidavit.
Only
An affidavit is in the process of being filed today.
Ma'am, it will be ready, it will be filed maximum by tomorrow.
In process of being filed, and the same shall be filed latest by tomorrow. So stop. Let copies of the said affidavit be served upon learned counsel for the rest of the parties by tomorrow. These matters on 1 week.
Item number 21.
But wait, please, Your Lordship. For item 21, with Your Lordship's permission, but I'm filing a counter to their writ application, which was tagged subsequently. So, can I be permitted to file the counter if Your Lordship?
File it. How many cases are there?
2 cases are there. In one case, the pleadings are complete. The other case, actually, I need to file a counter so that it needs the reply.
Who is
Yeah,
for
I
the
have served a
petitioner?
copy to my friend.
You're for the petitioner.
Management. Just now.
I served a copy.
Counter affidavit is going to be filed in
course of the
WPC
day.
number.
Sir, number is WPC. What is the other one?
12853 of 2014.
12853 of 2014 in course of the day.
In course of the day.
Stop. A copy of the said counter affidavit
already served
has been served on learned counsel for the petitioner. Stop. List this matter on 1 week so as to enable learned counsel for the petitioner to consider the said counter affidavit.
Item number 22.
My lord, on behalf of Mr. N. Linka for OPIT number 2, this matter kindly taken up tomorrow or day after tomorrow. He is not well.
Take up because these matters are urgent for the reason that they are pending for last 10 years.
My lord, my senior is not well. He is severely suffering from she is
When do you want?
tomorrow.
Tomorrow, as requested on behalf of the. Do you have any objection?
No, madam.
Petitioner, petitioner, you are for the petitioner?
No, I'm for the petitioner, I'm for the.
For the opposite party, list this matter on tomorrow.
Item 23.
An interim order, my lord. So, which is
Interim
I think
order?
till next date. If it is till next date, then
Tomorrow.
nothing is required. Otherwise, your
Interim
lordship,
order shall continue in the meantime.
all the 3 cases, my lord. There are 3 cases. Like,
Item number 23.
Lord, I have given a note with submissions.
So this has become infructuous. Nothing can be done now.
My lord?
The selection process is of 1996.
No. She has already retired, ma'am.
He is retired.
She already retired. After retirement, my lord, she asked for he falls short of 4 years qualifying service to get his full pension. My lord, thereafter, to get full pension, he has applied to the state government. It has gone through the Honorable High Court, and thereafter it is forwarded to state government. State government has refused on the ground that it's more note.
Note. Minute, 1 minute. Madam, I have given your lordship, see the note sheet, dead chat I have given. Dead chat I have given. Madam, nothing is disputed in the dead chat. Nothing is disputed. And the only thing in counter they say, annexure 10 is a bar to give you extension. Extension, madam. Madam, your lordship, see my submission.
What do you want?
I want 4 years extend 4 years qualifying service from the government.
On what ground?
Madam, but this is a hardship case, and by that
Hardship.
yes, ma'am.
Your entitlement will depend on the.
Yes, ma'am. But in similar circumstances, state government has allowed people in judicial service also. But state government, state government counter says, my lord, that because of annexure 3, he is not able to give. Your lordship see the refusal. Annexure 2. Annex. Next. Saved approach. Annexure 2, your lordship, see. At page 12. Page 12. In inviting a reference to Honorable Court's letter subject cited above, I am directed to say that. Page 12. In inviting a reference to the Honorable Court's letter on the subject above, I am directed to say that government, after careful consideration, have been pleased to regret the above proposal in pursuant to Annexure 10, resolution number 8. This resolution is Annexure 3. Next page, madam. Page 30. My lord, now in this juncture, my lord, I'll take you to the counter. Counter of the
No, what is your case? You can say that simple.
Yes, ma'am.
Simple stuff.
My case is.
You were a judicial officer.
Yes, I'm a
All
judicial.
right. Then what happened?
I have a qualifying service of 16 years. If I get 4 years more, then I'll get the full pension. I'll get the full pension. But in order to for pension, I have applied. I have applied to state government.
Your experience at the bar, you want to be counted.
Yes, ma'am. Yeah, my experience in the bar is 8 years. So I want that experience should be counted as qualifying service, and 4 years may be given. By that, I will get the full pension.
So you were appointed as?
Appointed as emergency judicial officer class 2.
And what was the minimum requirement for?
Minimum requirement is 20 years.
No, for your appointment.
For appointment.
Yes.
For appointment, in this case, emergency, it is 41 years. And it is relaxable to 3 years for women candidate. This is
Emergency recruiting.
Yes, ma'am.
That is,
The-
my lord wants to know whether there was any requirement of experience at bar, period of.
Five
experience.
years, madam.
Ah,
5 years requirement.
Is there any, can you take us to that document?
Take it to 5 years. That is in advertisement, my lord. That is not, I have annexed. But your lordship, I can show your lordship.
Four series, Annexer 4 series.
My lord?
Annexer 4 series, page 19. Page 19 is your experience.
Yes, ma'am.
At the bar.
Yes, ma'am. Discharge has given me that. 19. Page 19.
So why should that be added?
My lord, in so many cases, your lordship remembers that judges' cases in Supreme Court.
Judges' cases in Supreme Court.
One observation, only I say that one observation. My lord, your lordship see page, I have annexed the judgment.
36, page 36.
Regent.
Page 36.
Page.
Annexer 9. That is superior judicial.
No, not that one. My lord, your lordship see. Next it in the regent.
Sir, just think of this situation that you are claiming that period to be added.
Yes, ma'am.
Under which provision of law? You must show your right.
Yes, ma'am. Your lordship see. Page. Your lordship see. Page 58, annexure 24. Page para 24. Page 58, para 24. This is only observation, my lord. My lord, second para, the experience and knowledge. Your lordship got it? The experience knowledge gained by a successful lawyer at the bar can never be.
Where are reading?
My lord, page 58.
58.
Yes, ma'am.
There is no page 50.
Page 58. Regender, that is a regender. Your lordship got it? The experience and knowledge gained by a successful lawyer at the bar can never be considered to be less important from any point of view via
What is the internal page?
Internal page 13, Regender 13.
Regender is not there also.
And
Regender is not there in our view.
no, it is mark, page mark also there.
And physical copy.
This is 58 in continuous number 58.
Find it. It is stated by Learned Counsel for the petitioner that a rejoinder affidavit has been filed on behalf of the petitioner On?
It is a long before, my lord.
From this rejoinder affidavit. It's not there on record. Stop it. Let the registry find out as to whether such affidavit has been filed or not, and place the same on the court if has been filed on the next date. So put this matter on 2 weeks.
Item number 24.
It will be common. Tomorrow.
2 weeks. 2 weeks.
2 weeks.
2 weeks. The affidavit is rejoinder is not there on record. You say you don't have the date when it was filed. So they will find out. Implicit.
My lord, they have given the number also to us because continuous number, this is 58.
But our physical copy of the brief also does not show that. We
are not blaming you.
Anyway.
Item number 24.
In item 24, the petitioner has served a copy of the rejoinder right now. I have to take instruction on this.
This is regarding what?
That rejoinder affidavit has been.
Regarding what?
Counter
affidavit that was filed by.
This writ petition is regarding what?
Yes.
The writ petition.
What is this about?
The writ petition is with regards to charging of exponentially higher cost for the lease of the land, your lordship. Wherein on previous occasion, 2 lands were allotted in favor of the petitioner Samiti on a nominal charge of ₹1. But the state authorities, your lordship.
When was that provided? When was the lease executed? The first lease?
In the year 1976, your lordship.
At the rate of ₹1.
₹1.
And what have they done now?
Your lordship, those 2 leases were cancelled on the failure of delivery of possession of the land which was settled. So subsequently, in the year 1980. In the year 1988, the present piece of land was allotted in the name of the petitioner Samiti, but the lease was not executed. In the year 2009, the state authorities issued a notice calling upon the petitioner Samiti to be present for execution of the lease, and a charge was levied of ₹60,60,000. Challenging the said order, the petitioner Samiti approached before this honorable court, and an order was passed which was challenged by the state authorities before the apex court, and now the said matter has been remanded back before the law. Order that was challenged, your lordship. Supreme Court order. Supreme Court's order, your lordship, has been provided in the counter affidavit itself. Has been quoted in the counter affidavit, your lordship.
Please. We have got.
So what order is required to be passed has been mentioned in the order itself.
My lord, if the Honorable Supreme Court's order is strictly followed, according to my view, your lordship should send the case record to Lok Adalat.
No.
because amicably they can.
You have to take up
But
pursuant to this, you have approached the honorable apex court. And now you have to
there is a
take up the
mechanism.
issue with
Yes, there is a mechanism.
and then come forward to us.
Where is the question of, no, we will not do anything. The High Court, understand.
Your lordship may send it to local. High Court ought to have given an opportunity to both the parties to place relevant materials on record and then explore the possibility of some amicable.
Para 5.
Yes,
Yeah.
para 4.
Para 5.
Para 4.
Para 5.
I'm just going. In the particular fashion of the case, the High Court ought to have vastly make an endeavor to resolve the issue amicably. In case it does not happen, the High Court may decide. So for that amicable settlement, mediation, yes. That
Maybe
is
referred.
mediation. That is what I'm saying.
This writ application has been placed for hearing before us in the light of a Supreme Court's order dated 10/7/2023, passed in Civil Appeal number 4327 of 2023, bracketed State of Odisha, and another versus Sri Abhiram Shanti Anand Ashram Bhakt Samiti. Stop. The controversy involved, the controversy which the present proceeding involves has been succinctly noted in paragraph 2 of the aforesaid decision of Supreme Court, which reads as under paragraph 2. Stop. After having noted the facts and after having considered the facts and circumstances, the Supreme Court, while disposing of the said civil appeal, has observed in paragraphs 4 and 5 as under. Stop. In the light of the Supreme Court's order, above mentioned order, and with the consent of the parties, the matter is referred to Odisha High Court Mediation Center. That is the name. Odisha High Court Mediation Center for a resolution of the dispute between the parties by way of amicable settlement through the process of mediation. Stop. The dispute is accordingly referred to Odisha Mediation Center. High Court of Orissa Mediation Center. High Court of Orissa. No. Stop. The parties have agreed that they shall appear before the secretary, the coordinator mediation center on when? When will you appear? Monday?
Yes, Your Lordship.
On Monday?
Next.
Your
Yes.
officer must be there.
My officers will come whenever your lordship will that.
Monday.
Next month. Yes.
Monday, we can give time. Ah. On Monday at 10:30 a.m. Stop. The court expects that the coordinator shall refer the dispute to one of the learned mediators at the mediation center. Stop. List this matter on 1 month the time. 1 month from month from Monday se jo hota hai. So it is expected that learned mediators shall expedite the process of mediation.
If I may, Your Lordship, my humble submission subject to Your Lordship's acceptance. If a mediator may be fixed from here so that the matter can be expected.
There is a panel of mediators.
Yeah,
Coordinator will fix it.
Coordinator will do the needful.
Panel of mediators.
Coordinator.
Must you appear?
Yes. Much obliged, Your Lordship.
And how do we name? Because you have made this submission, tell us why should we name a mediator? They are there, depending upon the availability. Then
Much obliged.
Item number 25.
25, Your Lordship, direct to the government was filed an additional affidavit. They have served a copy last week. We need to file a reply to that. They have served a copy.
how much time?
1 week time.
A week's time is short, is being sought on behalf of the petitioner to consider rejoinder,
Reply to my additional.
to file reply to an additional affidavit which has been filed on behalf of the state.
State.
So for the said purpose, let's this matter on 2 weeks.
Yes.
Item 26.
May this is a public interest litigation regarding extending benefits to the boxing players of the state. Lordship may kindly turn to Annexure 1, page 9. The notification issued by the state government in 2013, my lord. In this notification, only 16 seats were allotted in the sports hostel throughout the state for admission of the boxing players. Out of 16, 8 for boys and 8 for girls. What happens, my lord? The process of selection is like that, my lord. In each and every year, a talent scout program is being conducted by the state government. My lord.
So what do you want? What direction do you need?
Lord, now the state government is taking their best efforts to promote every sport, my lord,
Then
in each and every discipline, but except boxing, my lord. In 2013-14, the last talent scout program which was conducted where the boxing was included, my lord. Thereafter, in each and every year, they are conducting the talent scout program, but the boxing discipline has not been included, my lord.
and cricket,
Like cricket, there is a separate body.
kabaddi.
Everything. Kabaddi is there.
It's a state policy.
Kabaddi is there, my
State
lord.
government will have to take.
Except boxing.
These are matters which are exclusively within the domain of the executive.
Unless
we don't
they
know sitting from here as to which game, which sports should be promoted.
Kabaddi, swimming, every discipline is included in the talent scout program except boxing.
Right, approach them.
Well, we have approached them. Only I humbly pray your lordship that your lordship may observe that in the forthcoming talent scout program, which is going to be conducted in each and every year, boxing may be included so that the state can produce the boxers.
Sorry.
This is my player, man.
Boxing was inducted and 16 participants were there, all were disqualified.
Well, that was in the year 2013-14. Pursuant to this honorable court direction, lastly they conducted a talent scout program for only for boxing, where 15 participants participated. But due to non-providing of the basic facilities, they could not qualify. So unless they conduct the talent scout program in the each and every year for boxing, how they will participate and they will get a chance to success? There is no coach, no training, nothing is there. Though all other sports have been promoted by the state government. And there are several boxing players who have represented the state in national games. And now they are playing through other states. Whereas we are taking steps for other games except boxing. If your lordship will observe that, then we'll get a chance for the boxers.
We don't issue directions. We can ask them to consider only.
And pursuant to your lordship's direction, we have also provided the names of certain players who are interested to do boxing as their career, my lord. Pursuant to your lordship's direction, they conducted a test, but
all of them declared disqualified.
my lord, that I am saying, my lord, due to non-providing of any benefits or any training, how they will qualify?
Who are you to suggest names?
My lord,
and who are we to tell?
I am the president of the Puri Boxing Association.
You means you are the council. Then you are the petitioner.
Yes, petitioner. The president of the Boxing Association.
You are president of the Boxing Association. You are suggesting names.
No, I am not suggesting names, my lord. I have collected the players' name who are interested.
Yeah.
There are the certificates.
That is the suggestion.
I have submitted the certificates and they have filed the affidavits. Thereafter, your lordship directed to conduct a training for them, but they disqualified. That is the result which was submitted by the state council. But unless they are provided proper training, how they will qualify?
And what about shooting?
Every discipline has been included.
Shooting is also included.
Every discipline.
There is
Except
training for
boxing.
shooting also.
I am not trained for shooting, my lord, but shooting has been included. Except boxing.
Shooting is not covered in this.
No, it is not covered in this PL, but it is included in the annual talent scout program. Except boxing, all this.
Annual talent?
Annual talent scout program. Yes.
Scouting program.
Scouting.
Yes, talent scouting program.
Talent scouting.
It is being conducted in each and every year by the state government.
What is the system?
System, my lord, the participants will participate in the talent scout and who will qualify, they will get admission in the state sports hostel and they will be trained by the state government.
So if I have a glance in on my affidavit dated 20th February 2024, annexure 1 of that affidavit at running page 3, 20th February 2024. For this year, this talent scouting program was conducted. There were 16 participants. My learned friend is naming those persons. They appeared, but all of them are disqualified. Then next year there will be a program and they will participate.
No, but that is his grievance, that they are disqualifying because you are not providing any training.
Training, so far as that is training is concerned, we are giving them. There is sports hostel and they are staying there. And I don't know how he's saying that they have participated in the program.
No, that is pursuant to your lordship's direction. That was conducted on a special direction before by your lordship.
So you may consider having a policy for boxing. We cannot issue direction. Yes, brother. Should be.
Can ask them to consider framing policy for. The petitioner seems to be open worker and president of Puri Boxing Academy. So, they have filed presented application in the nature of public interest litigation seeking direction to the opposite party to provide basic requirements to the candidates persons interested in boxing. Petitioner stop following release. Current counsel appearing on behalf of the petitioner has submitted that whereas the state government is voting all other sports boxing is being given and given a strict motherly treatment. No problem. He submits that there is that the state does not provide any training infrastructure for persons interested in the sports of boxing. He submits that such persons should be included in the talent scout program of the state government.
Annual talent scout.
Annual talent.
Annual talent scout of the state government. Next. From the order sheet, it transpires that the petitioner was asked to furnish names of 15 persons who were interested in boxing for their inclusion in the talent scout program. So they were made to undergo certain tests.
Talents.
Yes.
That is a program.
Selection process.
Selection process.
Selection process.
they get to undergo some selection process in which selection process. It appears from an affidavit filed on behalf of the estate that all such persons
Are declared disqualified.
declared disqualified. So, next, we are of the considered view that it is primarily the executive function to decide as to which sports is to be promoted depending upon the circumstances. So, exercising the power of judicial review under Article 226 of the Constitution, the sport does not have judicially determinable parameters to decide as to which sport should the government promote. So, next, in such view of the matter, we dispose of this writ application with an observation that which respondent?
Second.
Opposite party number 1 and 2.
1 and 2. Comment is 1.
Let respondent number 1, opposite party number 1 and 2 consider the issues which have been raised in the present writ application concerning the boxing to be for that being included in the
Annual talent scout program.
Annual talent scout program. So, the board expects that the opposite parties can, with all earnest, take up the issues raised in the within writ application and take a decision within 3 months from the date as received. Receive of the production of a copy.
Published. Much.
Item number 27.
May I please, minutes? This writ appeal is directed against the order dated 7/2019. 27 matter. This writ appeal matter is a file challenging order dated 7/3/2019 passed in WPC number 1720/2019 matter. The impugned order is at page 36, my lord. I am permitted to place the impugned order. From paragraph 2, my lord, I am placing. The petitioner has filed this writ petition seeking for direction to release family pension in her favor
Mr.
after
Sir,
death.
please.
Yes.
My lord. From subpara 2, my lord, I am placing of the impugned order.
Page 36.
Page 36.
On perusal. On perusal.
my lord, on perusal of the writ petition, it appears that there is dispute with regard to genuineness of the claim of the deceased employee by two separate claimants, namely Rebati Das and Snehalata Mahanti. So far as Rebati Das is concerned, it is contended that she is not claiming any benefit from the deceased employee, though she is a legally married wife of the deceased employee. And so far as Snehalata Mahanti is concerned, she is claiming retirement benefit of the deceased employee.
Who is legally married?
My lord, the case is like this. As per the records of the university, they have submitted a report before the government that one.
Who are you?
Well, I am also the wife, but
Also means what?
my lord, the university saying that one Rebati Das is the first wife. The Orissa OUAT, the university is saying the Rebati Das is the first wife.
So what is the stand of Rebati Das?
Rebati Das is not claiming anything, my lord.
Claiming is something else.
My lord.
Status is another.
My lord.
So whether she claims to be wife of the deceased or not.
No, my lord, because she is not claiming, even she is a party to this case, notice was issued. She did not.
Is the case of Rebati Das that she is not wife of so and so, your husband?
My lord, I cannot say this.
You cannot say this.
Because, my lord, at the time of my marriage, I was not aware that earlier he has been married.
Awareness again is irrelevant. The question is whether there is any dispute as regards the status of Rebati Das as the first wife of the employee or not.
Fact remains, she made a complaint after the marriage of Snehalata. Rebati made a complaint to the university authority.
Therefore, Rebati claims to be wife.
Yes, my lord.
She does not claim pension.
My lord, right.
And therefore, you will not become entitled to pension.
Well, as per the rule, I am not entitled.
Not entitled.
But my lord, my lord, one document, my lord, I want to show, my lord.
Yes.
A petition under 125 was filed before the STJ in Bhubaneswar. My lord, that order, my lord, I like to place before my lords.
Get that decided first.
No, that has already been decided.
125.
My lord.
In 125 proceeding.
Proceeding, my lord. That is my lord, running page 31, my lord, may kindly come to. Running page 31. Where the magistrate opined that I am the legally married wife.
For the purpose of 125.
For the purpose of 125. This is a persuasive document, my lord.
Persuasive, not that will not make you entitled to pension. And it has rightly been held by the learned single judge that you should move before appropriate forum.
My lord, that is there, my lord.
Proper declaration.
My lord, my lord, some document I have obtained through RTI. My lord,
RTI.
My lord, some documents. My lords may kindly see.
RTI, we will not look into that. Any information which you have received under the RTI Act,
My lord.
That cannot be the basis for adjudication. Adjudication is a different.
My lord is right, but my lord, my case.
Sir, you filed this writ application. When did you file the writ?
My lord, the writ.
19. You are in 2024.
My lord.
So in the meanwhile, you could have got decided your status, whether you are the wife or not.
My lord, notice was issued. Rebati is not appearing. She is not claiming. There is no other claimant. This is my case, my lord.
See, if someone is not claiming pension, therefore pension should be given to someone, is not the law.
My lord is right, but my lords kindly see my position. What I am, what problem I am putting. My lord, may kindly see running page 28, my lord.
Your problem does not have any.
My details of family, the deceased employee submitted the document nil. Page 28, my lord.
He is so kind to you. He can appear and tell that he is not the wife.
But my lord, the notice was substituted by way of a paper publication. But she did not appear. Notice was issued, not sufficient. Thereafter, substituting notice, paper publication is made.
As 47, order 7/50/2019, passed by a by of the court, number 1724 of 2018. The applicant claims to be wife of widow of the
मतलब शांतनु कुमार दास, शांतनु कुमार दास,
bad in harness.
Natural death, my lord. Died on 9/1/2011 after retirement.
9/1
2011.
after having retired from
Retired on VRS.
Which department?
OP1. OP1, my lord, the university.
Is apparent from the material from the record that one Revati Das claims to be the first wife of the deceased employee. Next, Learned Counsel appearing on behalf of the appellant admitted that the appellant was not aware of her husband's first marriage with Revati Das. So he further submits that Revati Das is not owing any pensionary benefits, and therefore he had approached the court. Therefore, the appellant had approached the court seeking direction for payment of family pension. So, next. From the single judge, after having considered the dispute raised in the proceeding, has rightly held that there being dispute between two persons claiming to be the wives of the deceased employee, unless proper declaration was made by an appropriate forum, no, the appellant's right to get family pension could not be decided. So, the single judge has observed in the impugn order that the single judge has granted the appellant a liberty to move before appropriate forum, ventilating her grievances for proper declaration so as to avail the benefit of family pension. So, we do not find any legal infirmity in the impugn order of the Honorable Single Judge. This appeal has no merit, which is
Item 28.
I am appearing for the OP1.
May please your lordship. That the matter was heard, my lord, last time, your lordship. The order of the land single judge is under challenge, my lord. I have given a date chart. Here, my lord, an employee of the bank, against whom a charge sheet with very serious allegations were given. Challenging that, he has filed a writ application. This honorable court directed that without granting stay, directed the disciplinary proceeding may continue, but no final orders be passed. When the matter was pending, my lord, the petitioner has retired from service. After retirement, my lord, between 2000 and 2017, he has retired. 2000, my lord, date chart, my lord, that is
36, 2017.
36, 2017. Second page of the note.
Date chart.
30th June 2017. My lord, the pension regulation came into force 12/12/2018. That is annexure 5, my lord, page
12/12/2018. Pension regulation.
101.
12/12/2018.
My lord, a book, a consolidated book, Mr. The other side advocate given last time. Wherein your lordship, that is annexure 5 is page 101. After coming to the post pension regulation in view of the existing regulation scheme, my lord, he filed an another writ application during pendency of that application in disciplinary proceeding for grant of pension. That is, my lord, the honorable single judge, taking note of the disciplinary proceeding and the pension regulation, granted provisional pension. My submission was the respondent number 1 has not come to the pension fold for entitlement pension because as per the applicability and eligibility of the pension, the employer has to fulfill certain condition, mandatory condition, which is chapter 2 of that, my lord, your lordship kindly.
Employee has to fulfill the condition.
Yes. That is, my lord, page 103. Chapter 2, applicability and eligibility of the pension. That, my lord, sub-regulation 3.
102.
Page 103. Page 103.
This is pension regulation.
Pension regulation starts from page 101. The chapter 2, my lord, which is applicability and eligibility condition, that is 103.
103.
Clause regulation 3(1)(c) is the regulation applicable to, admittedly applicable to the respondent number 1.
Regulation 3(1)(c).
C. So according, I am pleading, was in service of the bank between the first day of September 87 and 31st March 2020 and continued in service on or effective date, but retired before the notified date if he exercised the option in writing within 120 days from the date of notified
notified date. That is Millard 12/12/2000.
Reading page 103.
103. Application and eligibility. 3 class C. 31C.
Place class C again.
Yes.
Class C. you can-
Class C. Due to exercise option in writing within 120 days from the date of from the notified date to become a member of the fund and refund within 60 days of the expiry of the said period of 120 days the entire final amount received by him, the corpus comprising of the bank's contribution to Provident Fund under the Employees Pension Scheme 1995 and interest accrued thereupon till the date of so and so. That 95 that scheme Miller, that existing scheme. In lieu of that scheme, the new scheme can come. May I kindly come page 104, sub-regulation 2. Next page, Miller.
You have referred to 31C and then you are referring to
31C and now 32. Next page, Miller, that an employee.
32.
Yes, 32. Sub-regulation
Page
2 of 3.
104.
An employee or family of the deceased employee. Lordship got it.
yes, please.
Not exercising the option under sub-regulation 1 or who after exercising the option not refunding the amount shall be deemed not interested in becoming a member of the fund and shall continue to be governed under the Employee Pension Regulation Scheme 1995. That is earlier scheme which was enjoined by the employees. Millard, admittedly, within that 120 and 60 days, he has not defunded the amount.
So not compared with the requirement from the 3.2.
3.2. This is a mandatory and automatic, Millard. Your Lordship, kindly see the language. Excessive not refunding the amount shall be deemed not interested in becoming a member of the fund and shall continue to be governed under the Employees Pension Scheme 1995. So it is a deeming and Millard automatic. Admittedly, he has not complied within the time period. So, my respective submission that because he has not come to the fold of the pension scheme, and thereafter, Millard 2017 to 2000 up to 2020, he was enjoying that previous scheme, that is the pension he was receiving regularly. And this clause is not challenged also. These are the admitted facts. This is not challenged. He was receiving earlier pension and he has not deposited. That is the thing, Millard. Now, in view of that, if your Lordship holds that he has not come to the pension scheme, then the order of the land single judge is not valid and cannot be implemented. That is to go. That is one submission. The second submission of mine, Millard, your Lordship, that chair chart, your Lordship kindly see. He has, the charge sheet was issued on 30th December 2012, major penalty charge sheet.
Yes.
With serious charges, Millard, that is annexed to the counter.
If this is your submission, then why should we go in enter into any
Yes, yes. That is this thing, Millard.
He has been dismissed or not?
Yes.
Whether he any department he has been punished.
Final order passed.
Whether final order has been passed.
No, that final order, that's why I'm coming to, just I will take 3 or 4 minutes, 3-4 dates. 30/12/2014, 30th December 2014, that's not first page, Miller.
Yes.
First item. A the respond number 1 hereinafter refers the employee was charge sheeted in a disciplinary proceeding initiated by the appellant number 1. That is, Millard, Annexure 5 to the writ application. Also, Millard, in the present writ application against which the appeal is filed, Millard, there I have annexed it as Annexure A. That is page 35 to 39 of this book.
After charge sheet, what happened?
There, Millard, as per the direction, the proceeding continued. Inquiry has participated, inquiry report submitted, and thereafter second show cause you given. And we have, Millard, in 2016, we have filed an IA 7077 of 2016 to permit us to pass final order, because your lordship, single judge Millard, directed the proceeding to continue, but no final order passed without
When was that order passed?
That is, Millard, 6/10/2015.
So did you?
And Millard, 23/2016, as per the Liberty Millard proceeding, he has participated, and also some inquiry has participated, fully cross-examined the witnesses, and we have given the report along with the show cause. He has also submitted show cause. We wanted to get, Millard, permission from the Honorable Court to pass order. For that, Millard, 8 years passed.
Did you make any application?
Yes, application, Millard. After that, I have filed an application, IA number 7177 of 2016. In that case, Millard, and there also I have enclosed all the orders, Millard, show cause, inquiry report, and the second show cause, and his reply. Annexure A and B, I have annexed and filed. Last time, Millard, at this stage, your lordship want to know from me whether what happened that about the inquiry, that disciplinary matter. That was tagged with this appeal. Could not be taken. Your lordship deleted that and sent the concerned court for passing the order. There, Millard, they have taken time, some personal ground, that somehow that has no final order passed, that is posted to 20th. That is not necessary, Millard. Second, that is necessary in case, Millard, is dismissed from service. Even the pension the pension regulation is applicable. If in the proceeding he is dismissed, then he is not entitled for any pension and other benefits.
Why did we delete that matter? Because that matter was
Single bench.
Single bench, Millard. Now, as your lordship said, Millard, if your lordship holds that is not come to the pension regulation, is not entitled, the order of the lender single judge is set aside, then the matter will, now, Millard, he has filed a contempt petition. This Honorable Court directed, then single judge directed, Millard, with 7% interest to pay the pension. And because the disciplinary case pending with serious allegation, we have said it is not possible
when
to.
the matter was taken up last before the learned single judge.
Millard, last week it is posted to 20th.
20th.
Time, Millard, petitioner, Millard, for personal ground. That order sheet also I got it, Millard, if I am giving.
I am respecting you as a senior
Let
advocate,
me
but don't mislead the court. But at the time of hearing, that some question arising, Lord. Court wanted to see some documents, Lord. That is why the court kept the matter to the to
This is the order sheet, Millard. देखो 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 ये रहता है that one that one even my lord, for getting permission to pass final order, they are now, my lord, raising so many questions, so many things, and your lordship kindly see the annexure A to the writ application. Annexure A.
All right, we will wait for the decision. In that
May
case.
your, this, my lord, my
In your
liberty only to pass order so that appeal is there. Not, yes, I understand, Miller. That's why your lordship really deleted and sent it. But even that is not necessary for disposal of this.
We understand that.
Yes, yes.
We understand. If that is decided, if, see, if that is decided in your favor, or if you are granted liberty to pass an order.
Pass an order.
And if you take a final decision, then
He automatically
it will become infructuous.
very infructuous.
If the order is passed against you, then we will decide the matter. What do you
Only what objection they are not
May I-
able to understand. They are
The bank
participated.
wants to dictate the orders, my lord, here. My lord. The bank wants, my lord, the court should go according to its mercy, my lords. Yes, yes, my lord. Your lords kindly see, my lord. After the let this no, my lord, no, my lord. Your lords kindly let them show any order, my lords. Any order, my lord.
What order?
We have seen the order. We have
Yes,
seen the last.
yes, my lord. Last order, the court wanted, my lord. The court wanted, my lord. Yes, my lord. So, Lord, your lordship kindly see, my lord, your lordship's order dated 28/5/2020, my lord.
Yes.
Your lordship kindly see, my lord.
And the request of the petitioner
28
to list the matter and Purbotami
Yes,
Sita.
we will take up the matter on
Petitioner.
28, 20.
My lord, I am a retired person, my lord. My lord, I am a retired person. They have stopped my pension. They have stopped my gratuity. They have stopped my leave salary. Please.
Sir, counsel,
My lord,
please don't raise voice in this court.
my lord,
Never do it.
I'm sorry, my lord. I'm sorry, my lord. My lord, I'm a retired employee. My lord, I'm 68-year-old, my lord.
Yes.
The bank has stopped pension in spite of your lordship's order, my lord. In spite of your lordship's order, my lord. Bank has, my lord, that is 28/5/2020, my lord. That is, I'm going to read, my lord. Your lordship's order, my lord. I'm like 28/5/2020, my lord. May I read, my lord? Well. Also got it. 28/5/2020.
Order number?
Order number 4, my lord. 4. 4. You also got it.
There shall be interim stay
Miller,
on payment of-
hard or Lawrence counsel for the parties pending disposal of the writ appeal, there shall be interim stay on payment of provisional pension with interest by the respondent for the period prior to the date of passing the impugned order on 17/10/12/2019. However, the appellant shall continue to pay the respondent the provisional pension from the month of December 2019 and thereafter in the first week of every succeeding month, Millard. Millard, your lordship's direction, Millard, they were paying, Millard, but in the 2023, 22 or 23, Millard, they have withheld 70% of the amount, Millard, without modification of this order, Millard, without modification of order, Millard. When this
This you could have told us softly. There was no requirement.
I'm sorry, I'm sorry, I'm sorry, I'm sorry, I'm sorry, Millard, extremely sorry. I beg apology, Millard. Millard, then, Millard, your lordship kindly see order dated 2011-2023. Order number 10, Millard.
Order number 10.
10 Millard. 2023.
Regulation 47.
Well,
May I submit, my lord?
that is not, I am crippled, my lord. My lord,
My lord, after this, my lord, he has taken house building loan, educational loan. As per the regulation 47, my lord, we have given notice that you clear the amount. Now we have not withdrawn that amount. That amount which that loan has taken, that amount is deposited there. That the bank has not taken the loan which he has taken. He has retired as per regulation 47, Miller. The bank has power to even pension he is getting, we can even deduct from the pension and deposit in the loan account. That we have explained.
Your lordship may see regulation 47. Well, Miller. It pays 120 millers. 120. Recovery of bank's dues. The bank shall be entitled to recover the dues to the bank on account of housing loans, advances, license fees, other recoveries and recoveries due to staff cooperative credit society from the commutation value of pension or the pension or the family pension, not from the provisional pension. Provisional pension is specifically, your lordship kindly see, all provisional pension, family pension, and all are defined, Miller, under this rule, Miller. Yes, Miller, your lordship kindly see.
Awaiting decision. In WP number, what is the case?
16810.
16810.
This is matter of.
It is pending on 20th. It is pending. It has been posted to
20th. Posted to 20th. 20th.
20th.
28th March.
20. 20.
28th.
28.
Before the letter single job, it is 20th.
Courier posting
20th.
That is, this application is posted that 20th March. Your lordship may call it
28th. That's why we are saying.
Yes, sir.
Yes, Miller, they have stopped my gratuity. Miller, I'm crippled. Miller, I'm crippled, Miller, sir.
If you file an affidavit that there is no loan amount on you, we will initiate contempt proceedings.
Yes, Miller.
Otherwise,
he has. I'm just explaining this, Miller. The loan amount I had taken loan of 10 lakhs, Miller. It was in the loan scheme, Lord. It was mentioned that the loan, the interest will be carved out from the.
we are not interested in that.
No,
we will not
you
enter
lost
into
the
that dispute. We will wait till decision in that case. And
one minute. But in the loan scheme itself, it is provided that on the date of retirement, if there is any outstanding, that will be recovered from the gratuity, Millers. That is there, Miller. 16 lakhs gratuity and leave salary is with them, Millers. It should have been carved out, Millers.
Whether Miller pension they will get or not, that is the issue.
Pension, Miller.
Pension will get or not.
Blood, I have crippled blood bill. It violates principle of natural justice. Blood.
Item 29.
One hand they are crippling me, and another they are saying fight with the case. Blood.
Huh?
Fight with the case. Blood, what I am not shouting. Blood, I am not shouting or insulting anybody. Blood, I am not shouting.
You are. It is not that you are being kind to us by not shouting.
Blood, I am not shouting, Blood, but
yes.
Or nor I'm insulting my anybody.
You cannot.
Blood. I never miss. I never miss.
Yes.
I never miss.
Yes. Please come.
Item 29.
Maybe.
Well, the order of honorable single judge at page 92 annexure 6, ma'am. Page 92.
Yes, what is that?
Ma'am. May I draw my lord's notice to page 104. It starts from para 12, ma'am. Para 13. In response to the above, an affidavit has been filed by the opposite party number 3. In paragraph 2 and 3, whereof it has been stated as follows. That the deponent humbly submitted that the petitioner was appointed as a teacher on 1/12/1984 and is rendering his service from 7/12/1984. As the resolution dated 24/2/94 clearly stipulates that no assistance shall be made available in respect of the post. And I'm reading para 13, 1-3, 13 mile, 1-3.
Yes.
At page 104 mile. In response to the above, an affidavit has been filed by opposite party number 3 in para 2 and 3 whereof it has been stated as follows. That the deponent humbly submitted that the petitioner was appointed as a teacher on 1/12/1984 and is rendering his service from 7/12/1984. As the resolution dated 24/2/94 clearly stipulates that no assistance shall be made available in respect of post created or staff appointed by the organization unless it is obtained prior approval of the government. Accordingly, the selection committee on 21/1/2004 recommended the name of petitioner for regularization with effect from 24/2/1994. The recommendation was considered by the government and allowed for regular scale of pay with effect from 1/7/2008. That the deponent further humbly submitted that no record is available in the office of the deponent yet to file. The government accorded approval for the post of petitioner with effect from 1/7/2008. In the meantime, a new department was created for social security and matter pertaining to the present is coming the administrative control of the newly created Department of Social Security and Empowerment of persons with a disability. As such, the record has already transferred to the said department. On perusal of the aforesaid paragraph 2 and 3, it would be evident that reasons for not extending the benefit of the scale of pay admissible to the petitioner pursuant to resolution dated 24/2/1994 has not been indicated. Furthermore, there is no rationale behind extension of benefit to the petitioner with effect from 1/7/2008 instead of 24/2/1994. In view of such position, this court is of considered view that the petitioner is entitled to get the regular scale of pay with effect from 24/2/1994 pursuant to resolution dated 24/2/1994 and not with effect from 1/7/2008 as has already been granted. Therefore, thereby the benefit admissible to the petitioner should be calculated and extended with effect from 24/2/1994 pursuant to resolution dated 24/2/1994 in Annexure 2 as recommended by the management instead of 1/7/2008. Accordingly, the state of your director to compute the entry of the petition as per the above. May I draw my lord's notice that resolution dated 22/2/1994.
So what is wrong? in
Yes.
this order?
Yes, my lord. Your lordship may draw my lord's notice to resolution dated 24/2/1994. What the resolution says. The resolution, there are certain conditions are stipulated for releasing granting aid. What are the conditions? Your lordship can find it page.
No, but single judge has recorded that there was no material
My lord.
to show as to why the petitioner was to be given this
benefit-
benefit with effect from 1/7/2008
Yes, ma'am. That
instead of 1994.
yes, ma'am. Yes, sorry.
So was there any material before the grand single judge?
Yes,
Was there any?
yes, my lord.
Yes.
My lord. That was my affidavit. I've come to that affidavit.
Come to that.
Yes, ma'am.
Yes. David finally yes.
My lord, before honorable single judge, my lord. Page 79, my lord, annexure 5. Page 79.
Annexure 5.
My lord.
Yes. What is there?
Your lordship, paragraph 10, my lord.
Page 79.
It starts from page 79, the affidavit.
WPC 3459.
Yes, my lord.
W.
Yes, my lord. Yes, my lord.
3459.
Yes, 3459.
Page 77.
It starts from page 79, my lord.
Page 79.
My lord.
Is the relevant page. 83 is the relevant page.
My lord, page 76 was affidavit, earlier affidavit.
83 is the relevant page. Para 10 you are referring.
My lord. Six five of the resolution number 551 dated 24 to 1994 for regulation of service, the petitioner Srimati Bharati Das aggrieved and filed a case before the Honorable High Court bearing OJC number 2310 of 1996.
But that is not the reason. That cannot be said to be reason.
Now, why that reason, my lord? I am explaining, my lord. The resolution speaks, the management is to submit a proposal before the government for release of granting aid. When the management did not submit the proposal, he approached my lords. Your lordship had disposed of the writ petition to take a decision. Accordingly, the government directed the management to submit the proposal. As per the resolution dated 27/2/94, unless the management submits a proposal, aid cannot be released. That is the condition of the resolution.
But the fact remains that you admitted in your counter affidavit when was he appointed and he was to be, but after you got the details from the management, you learned.
The management submitted the proposal in 2004. Thereafter, she was terminated by the management. She was reinstated in 2008. And that resolution is not automatic. One will get that benefit from the date of that resolution.
She was terminated from service, that is there on record.
Yes, but that I have mentioned here. In part, that in the year 2000, Srimati Bharati Das was terminated, removed from the service by the management. That termination order was, she challenged here, that termination order was quashed. Then he was reinstated in 2008. And I will bring my lord's notice to that resolution. What the resolution says, unless the management submits the detailed proposal, we cannot approve and release the benefit. Aid is not automatic. This is the reason we have been that has been assigned in the affidavit.
No, but think from another perspective, what is her fault?
But the granting aid policy says so. Yes, yes, ma'am.
Consider your submission also, but what is her fault? She was dismissed from service.
By the management. By the management.
Dismissed from service. But that was not her fault.
That was not her.
That was found to be not correct.
Not correct.
That was quashed.
That I am not disputing my lord's.
Then everything is admitted by you.
No, that they have submitted the proposal. Let us I am considering for a moment. From which date at least she is eligible. If that termination is declared bad, and if that termination, let us assume that is bad and not for her fault that she was terminated, then at best she is entitled to get the aid from 2004, from the date when the management submitted the proposal.
No.
Yes, my lord. The management submitted despite government's letter. Because in order to receive the granting aid, the management to fulfill certain.
There has been some dispute about her appointment, initial appointment, the matter would have been different.
Yes, my lord. That we have called for the records. You submit all the proposal. Government not once. Thrice government has called the management to submit the proposal.
You admitted.
Yes, in 2004. That
your counter affidavit, which has been noted in the order.
That is the affirmations I have shown my lords that we have taken that stand.
Therefore,
yes, ma'am.
the petition has been decided because of your statement.
That is the statement I have shown my lords, that para 10. Para 10 and 11. That is the statement we have shown. So 5 that are not granted, that I have stated, that is my lords. If I show my lords that resolution, your lords, there, because admitted fact that she was terminated, my lords, I agree with my lord's proposition that there is no fault lies with her. But the resolution.
No. There would have been a circumstance. Had you been taking a stand that you don't know when was she appointed?
Yes, that was the stand before that. We have directed them to submit all the proposals.
You directed them, but
yes.
Finally you admit you take this. Who was the respondent 1 and 2, opposite part number 1 and 2? Before the report?
Opposite part number 1 is the government.
Government. Government takes stands that the petitioner was appointed in 81 or 80, I don't remember the date, and then subsequently everything was received. So when the facts are admitted, then why should you deny?
Yes, my lord. He was appointed by the private management. That institution as governed, regulated by NGO. That's not a government institution.
You don't dispute it.
No, well, in 94, we extended the benefit by virtue of that resolution. Aid was extended by virtue of that resolution. May I show my lords that resolution?
Yes, sir.
That resolution is at page 24. The page 24, page 25, clause 5 is relevant. That is not legible. I have typed it in my grounds of that writ appeal, my lord.
Page 24 of?
24 of the writ appeal, my lord. It starts from page 24. That resolution 5 and 6 are important, my lord. I have quoted in my grounds because that is not legible in that copy. That was annexed before Honorable Singular by the respondent, so I have annexed that document. I have quoted in my a person already engaged in the recognized having passed the minimum qualification required the post will be allowed salary as per norms. The list of the staff members and scale have been approved by the government. Requirement of qualification has been made against the post already approved by the government. No assistance shall be made available in respect of post created or staff appointed by the organization unless it has obtained prior approval of the government. Recruitment of staff has been done by the selection comparing the district social welfare officer of the district, inspector of the school, secretary of the organization, observing all formalities and duly approved by the director, state government of Odisha. These are the conditions, my lord. Accordingly, your lordship may see that annexed up. I am showing that annexed up.
No, where is that stipulation?
My lord. A person that these are the conditions
That-
unless you
That remains somewhere, some missing lines.
yes, because
You see, from page 6 to page 7, there is no continuity.
Pattani.
Page 6, 7, possibly 9. Page 6 to page 7, where is the continuity?
It is only submitted.
Page 6.
Page 6, these are the conditions. The following conditions: 1, 2, 3, 4, 5.
Duly approved by Director SW Government of
Odisha.
Other it is stopped.
Odisha is stopped. Whether these conditions are fulfilled or not, we sought for clarification the management. Your lordship, he has annexed all those documents in the read petition. Your lordship, page 28. Your Lordship, turn to page 28. Mary.
Because of the affidavit which you had filed,
That all the materials before my lord, that they have annexed those documents also, that the documents are with the pre-petition, my lord. That we have not admitted that he has, our stand is before honorable single judge was that, because that proposal was submitted like just terminated.
That the recommendation was considered by the government and allowed for regular. And third paragraph, that the important difference further only submitted that no record is available in the office of the department as to why the government accorded approval for the post of petitioner certificate from 1/7/2008. What else?
But means in subsequent, in para 10 and 11, we have, in para 10 and 11, we have clarified that. In compliance to my lord's direction, on honorable single judge's direction, we have filed an additional affidavit that was filed on 4/9/2019 in my
Judgment dated 3/1/2020. In that time, was in WP category C number 3459 of 2010. Thereby, the application filed as a 26 of the Constitution of India by the respondent came to be the correspondent had approached making motion of conversation of who was the opposite partner now?
government of police.
State of Orissa dated 4/8/2008, whereby he was allowed regular pay scale with effect from 1/7/2008, as he claimed that he was entitled to regular scale with effect from 24/2/1994.
Well,
Next, according to the respondent, he was appointed as a teacher and subsequently designated as special educator, appointed as special educator with effect from 7/12/1994 by
7/12/84, my lord.
7/12/1984
My
by management of the quote unquote school for mentally retarded, Balaso, on consolidated salary of ₹500 per month. So, the school was subsequently recognized by the government of Orissa and started receiving grant in aid from 1986/89. in December 1985, the state government is said to have, the state government formulated set of rules for the institutions imparting education to minors, deaf and mentally retarded children. So, the said scheme, however, did not have any provision to recruit teachers and provision for recruitment of teachers and determination of their pay scales. So, it was in that background a resolution was issued on 28/12/1987, providing scheme for engagement and salaries of teachers. So, the said scheme remained unimplemented. So, subsequently, by resolution dated 24/2/1994, the state government came out with separate scheme laying down the norms for fixation of yardsticks for teaching and non-teaching staff of the school, of such schools. So, it is not in dispute that in accordance with this said resolution, a special educator was entitled to scale of 1,400 to 2,600. So, as the said scale was not allowed to the petitioner, he had to approach this court by filing a writ petition giving rise to OJC number 2310 of 1996, with a prayer to allow her the prescribed scale with effect from 1/4/1994 in accordance with the said resolution dated 24/2/1994. So, the writ petition filed by the respondent and other two teachers of the same school were disposed of on 18/9/1999, asking the state government to consider the proposal of the management of the said school for fixing pay scale. So, the management of the school, it appears from the impugn order, had already sent the proposal to the state government. So, Next, it also transpires from the impugned judgment, which is not in dispute, that after the order was passed on 18/8/1999, the management of the school was directed to resubmit the proposal with the proceedings and recommendations of the selection committee. It further transpires that there were certain communications between the state government and the management in relation to payment of fee. Finally, the management sent the proceedings of the selection committee on 21/2004, whereafter the appellant
Respondent. M. Respondent.
Thereafter, a communication was sent to the management intimating approval of regular pay scale in respect of the petitioner with effect from 1/7/2008 and grant him aid in the approved scale pay scale was released in favor of the petitioner on 28/2/2009. So, the opposite party represented before the authority against the decision to grant her pay scale with effect from 1/7/2008 to the grant in place. By treating the petitioners, treating the respondents' pay regular pay scale with effect from 1/7/2008 instead of 17/4, what is it? 24/4/1994. The petitioner approached this court by filing WPC number 3459 of 2010, as no decision was taken by the state government on her representation, moving benefit of regular pay scale which is from 24 to 1994. So, in order to cut the matter In order to cut the matter short, we deem it proper to refer to the pleading in paragraphs 2 and 3 of the counter affidavit, which was filed in the writ court, which referring to the facts admitted in the counter affidavit by the appellants slash state government and single judge has recorded that there was no reason disclosed for denying the benefit of scale of pay with effect from 24 to 1994, and there was no reason nor rationale behind fixation of 1/7/2008 as the date with effect from which the respondent should be entitled to regular pay scale. So, next, learned AGA representing the state has drawn this court's attention to the relevant portion of the resolution dated 28/12/1987 with particular reference to paragraph 6.
Resolution dated 24 to 1994.
24
to 1994 resolution.
24 to 1994. Four.
My lord.
Annexure 2.
Annexure 2.
24 to 1994. Which annexure is there?
Annexure 2, my lord.
Here also.
Yes, ma'am.
In the writ appeal.
Read petition, my lord, that lordship can get it from page 20.
Writ appeal, whether that is the
Yes, 24.
annexure, page 24.
My lord.
That is not legible.
That is not legible. So from the beginning, I have submitted. I have just quoted that.
So you have quoted at paragraph
page 6 of my writ appeal.
That is also quoted by Honorable Single Judge.
Yes, but that in that order 1987 is mentioned. Just see that from. See that part of the order where the that is a part of the resolution has been quoted. Which page you are saying?
Page 6 of my writ appeal, I have quoted. Grounds, below the grounds, B.
Which? With definite reference to paragraph 6 thereof, which reads as under and has been quoted in ground number 2 of the grounds taken in the present writ appeal. Colon dash page 6, 1, 2, 3, 4, 5. So he has submitted that it is evident from the readings on record that the management had not sent the requisite proposal before which date of 2004?
That is on 21/1/2004. On that day, selection committee was held.
21/1/2004. 21/1/2004. So he contains that in no case the state government could have granted, could have approved.
Yes, ma'am.
What is the approved?
Extend the granting aid, my lord.
Extend the benefit of grant in aid prior to receipt of the proposal.
A selection committee, recommendation of the selection committee.
Which selection?
The selection committee recommended on that the entire dispute is that selection committee recommended on 20 for that reason I was drawing my lord's notice that page 33. That was the proceeding of the selection committee. On that date, they recommended his case.
Oh, what is selection?
Selection committee to be considered and recommend for selection of those candidates.
Selection was
Prior to that, but not in accordance with that resolution that who have fulfilled, those who have fulfilled the condition outlined at resolution, they
and we have understood from what is there in the order sheet that you demanded
the documents.
Just a minute.
Sorry,
Demanded from the management the proceedings of the selection.
Yes, sir.
Those proceedings were not made available to you. And those proceedings were made available to you in 2004. It is not that in 2004 the selection committee
Yes,
was there.
Yes, sir. That is the page 2.
Proposal was given in 2000. That is their affidavit. That they have not.
Allow me for a moment, page 33.
Page
33.
Yeah.
Plus, you got it. That is the proceeding of the selection committee meeting held on 21st January 2004 at the premises of Handicap Mission Compound, Baleshwar.
Selection committee previously met in 2000 and proposal was given. Thereafter, they asked for compliances of this and that. Therefore, it was again submitted in 2004. And they admit that in their affidavit it was first submitted in 2000.
This selection committee was not for the purpose of selection. This was only for the purpose of agreeing of scale of.
Yes, ma'am. That scale of pay, that I would. Yes, ma'am. That we have. That yes, only that is the ground.
The selection was made in 2000.
No, my admitted fact selection was in the 84.
Yes.
Yeah, that. But only ground that we have taken, this is the ground. Except that we don't have any ground.
Contains that in no case the state government could have estimated prior to receipt of the proposal.
Yes,
from the management. So he submits that he submits referring to which annexure it is?
Page 32, Madam.
33 is which annexure? He submits referring to communication dated 31/2004 made by the management of the school to submit that the selection committee meeting, that meeting of the selection committee of the school was held in 2000 and subsequently on 21/1/2004. So stop. In such view of the matter, the appellants were right in their decision to grant regular pay scale after receipt of the proposal.
Well,
So he has also argued that the respondent was dismissed from service by the and she was reinstated in service under the order of this court. When were you reinstated?
I have filed that order reinstated with observation that her seniority will be maintained and all her.
When were you reinstated?
1 minute. Sorry.
You are sitting here for one
No.
hour here.
Reinstated order was 19/2/2008. Pursuant to that order, she was reinstated in service.
19/2/2008 was passed by this honorable court.
Yes, that was the order by the
WPC
honorable
number
court.
785 of 2005.
When was the
Management can say that
He was reinstated exact date. After that, I have not mentioned that exact date.
copy has submitted and will be reinstated in 2008. He accordingly submits that it was the consul's decision based in the background of these facts that a regular pay scale in case of the respondent was allowed with effect from
1/7/2008. Was allowed with effect from 1/7/2008.
1/7/2008, the speed of 24/2/1994.
Yes, Malak. 24/2/1994.
24/2/1994. Comma, the same being the date of the launch of the state government. Documents we have carefully perused the materials on record and have considered the submission advanced on behalf of the parties. From we find justification in the impugned order passed by the learned single judge wherein it has been held that the state failed to explain the rationale behind allowing the respondent a regular escape with effect from what is 2008? 1/7/2008. So, an alternative
argument has been made, an argument has been launched on behalf of the state that if not 2008, 17/2008, comma, petitioner, the respondent cannot claim benefit of regular pay scale from a date prior to the date of receipt of the proposal. So stop. Proposal, and that was the requirement in the resolution of the state government. So stop. We are however of the view that the state has not disputed the factual aspect that the respondent was appointed by the management in
7/12/1984.
Okay.
Seven 12/1984.
On 1/12/1994.
Yes, 7/12/1984, my lord.
On 7/12 was appointed on 1/12/1984 and has been rendering her service, had been rendering her service since 7/12/1984. So it is an admitted fact in the counter affidavit filed by the state of Orissa herself that no report was available in the office of, on behalf of, in its office, in the office, as to why the government had accorded approval for the petition for the respondent's post with effect from 1/7/2008 instead of 24/2/1994. So, next, certain the situation, comma, in an intra-court appeal, comma, we do not find any reason to interfere with the implement judgment and order of the single judge rated student. This appeal, comma, in our opinion, has no merit and important.
Item number 30.
My lord, item number 30, my lord's clause list. So that counter not filed, but I have filed counter, my lord.
Your lordship, 2
I have
weeks time.
refiled it. I have soft copy. If my lord want, I can submit the hard copy.
Your lordship, 2 weeks time may be given. I'll file return to your lordship.
This is the petitioner.
Petitioner, your
This is the
lordship.
petitioner.
I'm for the petitioner.
Petitioner, ma'am. This is writ petition. 30, ma'am. 30. This is the writ petition.
Allowed to run counsel for the petitioner to consider the counter affidavit filed on behalf of the state and file grinder is for advice. This matter on 2 weeks.
Item number 31.
May I please, Your Lordship? But in this appeal, the order passed by the Honorable Single Judge in respect of an order arising out of Orissa Development Authority Act is under challenge. My lord, there is a inter se dispute between the present appellant and present respondent number 5, whom allegedly in the year 1983, a shell deed was executed in respect of a portion of the property where, my lord, the construction is directed to be demolished, my lord, and a suit is pending inter se between the parties which ended in dismissal. A first appeal injunction was sought for. Injunction, my lord, was not entertained. A CMP has been preferred before reasonable court, and in the CMP, inter se between the private parties, an order of status quo has been passed, and that is pending consideration. And I have filed the copy of the plaint and the order passed in the CMP, which is before your lordship at flag F/1. That is before your lordship on board. Now, so far as the present dispute is concerned, my lord, it relates to the construction of 2 pillars and half constructed sheds over a portion of land appertaining to plot number 580 and 581. Now, the opposite part, respondent number 5, claims to be using that as a passage, and that is how the dispute has arose. During the pendency of the appeal before the reasonable court, this appellant had undertaken to remove both the pillars. The pillars have been removed, your lordship, and affidavit has been filed, and that has been confirmed by the CDA also by filing an affidavit. Now, the other portion that remains is, my lord, in the notice that has been, my lord, appended to, your lordship will kindly see the IA I have filed. In the IA, the notice that has been annexed. That is IA number.
So what is wrong with the order?
My, here what has happened.
This is the civil dispute. Should be decided in suit.
And that is there in the suit so far as the parties are concerned. Now, the CDA wants these, they have, in the notice they had mentioned other temporary structure. Now, when a query was made by this noble court, what do you mean by other temporary structure? They have clarified it by filing an affidavit for your lordship, which is at flag D, your lordship. Therein in paragraph 5, I am the person whose these structures are sought to be demolished by virtue of
the suit is pending.
But the suit is inter se between the respondent and other parties and the appellant. CDA is not a party so far as the suit is concerned.
CDA is not a party, and if you don't want to intervene, the dispute, see, one dispute shall not be decided in the civil court and the other in the High Court.
May I humbly clarify one thing? So far as the suit is concerned, if your lordship will kindly peruse the plaint that has been, my lord, at flag F that has been filed for your lordship, the suit pertains to where the shell deed that was executed in the year 1983 in favor of the respondent number 5 has been questioned, and the suit ended in dismissal, your lordship. First appeal was preferred.
So you are not going to be affected by any decision, whatever is taken by the civil court.
No, it is me who filed the civil suit. I was the plaintiff.
You are the plaintiff.
Now
you are.
I am the plaintiff, and I have preferred an appeal before the first appellate court. During the pendency of the appeal, injunction was sought for. Injunction was not granted. CMP was preferred before the reasonable court. In CMP, order of status quo has been passed, and that CMP is pending. This is the position so far as the inter se dispute between the present appellant, who is the plaintiff in the court below, and the respondent number 5, who is defendant number 1 in the court below, and other defendants are there, my. Now, this dispute pertains to the demolition order that was issued by the CDA authority, confirmed in appeal and confirmed by the Honorable Single Judge. Now, on order of status quo is there, inter se between the parties. Now, these are
Honorable confirmed by which order?
By the present writ, my lord, the writ order which has been challenged in this appeal, my lord, that is at annexure.
Your order has been confirmed.
Order regarding demolition of the structures
Has been confirmed.
Yes, ma'am.
You want this to be certified?
That's what I have challenged, my lord. That is what I have challenged, Your Lordship.
Sir, your order has been affirmed by learned single judge, and you want that order to be set aside.
No, my lord, possibly, my lord, I couldn't present it.
We are not.
No, I'm extremely sorry I couldn't present the fact correctly. But there are two aspects. One is civil suit relating to where I have paid for a declaration that the sale deed that has been executed in favor of respondent number 5 is void and for other relief. That suit has ended in dismissal. First appeal before the land district judge was preferred. First appeal is pending. Injunction was sought for. Injunction was not granted. CMP was preferred against that order before this noble court. CMP.
What is this about?
This is about, Your Lordship, this emanates from the order that has been passed by the CDA authority in exercise of power under section 91 of the Orissa Development Authority Act, directing demolition of those 2 pillars standing over the land and same land, Your Lordship, and 2 temporary structures. Now, when a clarification was sought for by this noble court,
unauthorized structure.
Yes, Your Lordship, that approval has not been taken. Now, when this noble court sought for a clarification,
These structures are not subject matter of that. Those neither the suit nor.
in the suit, the property is subject matter, but the structure is not subject matter. Injunction has not been because CDA is not a party so far the suit is concerned.
You are saying you have filed suit. You are saying you are not a party.
No, I am the plaintiff, Your Lordship, in the suit.
You are a party.
Yes, my lord.
Why are you saying that you are not a party?
No, I am saying that this structure demolition is not subject matter of the suit. Will Your Lordship kindly peruse the plaint at flag F by 1?
Make the court understand things.
May I just clarify?
He
told me a piece of land in 1983. The present appellant.
CDA.
Yes. Not CDA.
Just a minute.
The present appellant. The present appellant sold me a piece of land.
Who is the appellant?
Dologobindo Sahu.
And you are not CDA.
No, I am
I am not CDA. CDA is my land friend Mr. Mahapatra is appearing for CDA.
And you have filed the suit.
Yes.
What is your name?
Dologobindo Sahu, Your Lordship.
And you are for?
I am for the opposite party number 5, Purushottam Lal Kandui.
Yes.
He has sold me a piece of land in 1983. Thereafter, my lords, he wants somehow or other. And if your lordship sees the sale deed, he has given me a right of way over his own land to approach the public road. Now, thereafter, he wants me to prevent the user of the property which he has sold to me. So he filed a suit to set aside the sale deed. That suit was contested, it was dismissed. Now, thereafter, what he has done is, on the road that he has provided to me, he has constructed shop rooms and a temple. And he has also constructed pillars to affix a gate so that I cannot access my property. Since he failed to get an injunction before the civil court, this is a devious method which he adopted. So I made a complaint to the CDA. The CDA inquired into the matter and found that the constructions which have been raised by him are absolutely unauthorized. They ordered demolition. He carried the matter in appeal before the appellate forum. The appellate authority confirmed the order of demolition. He carried the matter before the learned single judge in a writ petition. The order has again been confirmed. Now he is in appeal. So that is the long and short of the case. And if your lordship sees, I've given the photographs of the offending constructions. If your lordships will kindly see that.
You'll see, we'll sign it now. But we are not happy the way the case is being conducted. This petition not to have been. You decided to coming up. You will say that. Item and chapter. Item, we are not in a position to take up all the matter.
They have tried, but item 34, my lords, item 34.
Just a minute. So which part matter of 39? 39.
So this was.
This was called 39. 31. 31 is 131. Up to 40.
34, my lords.
Up to 40.
Up to 40, my lord, item 39, day after tomorrow,
Item 34, my lords. Item 34, my lords. Maybe taken up 2 weeks after. Mr. Misra was appearing for the appellant. He has also requested me to take time because of his ill. I am also ill. He's also ill, unable to speak correctly because throat infection and all these.
Appearing for the appellant.
So maybe taken up 2 weeks after, my lords. What?
Weeks after.
Interim order to continue.
Item 30.
Interim order to continue.
May I pardon,
46 can be no 46. Item
may I pardon in item number?
Item 38, madam. I have filed a written note yesterday. To allow written note, madam. Not for this. Item 38. Written note I have given yesterday filed in UHT, madam. Register, madam.
What have you filed?
Written note submission.
42, mile.
32 may be taken up there. 32.
32 someone has mentioned. No.
Madam, item number 46.
32 what do you want?
Day after. 36 may.
32 in
36 may be taken up next week.
and 32
Next week.
Madam, can you item 36? 46.
35, my lord, day after tomorrow.
35.
Milord, in item number 32, some of my friends have made a mention, Milord. Milord, in that case, the association which is a stakeholder, that is the photographer association, it has filed an intervention application. That has not been included. I am providing the number of that.
We will see when the matter is.
Obliged.
Madam, I am discussing your worksheet. Item number.
Yes, up to 40. Everybody.
Sir, after item number 46, if the urgency is there, we have to be evicted from the land.
Make a mention tomorrow. We will pick up.
Item number 40.
Make a mention in the morning. Ask the other side who is appearing.
Item number 42, my lord. 42. Well, a batch of cases, my lord. That is the additional fees of rupees 59 that has been set aside by this honorable court, my lord. Other high courts also, my lord. That is covered by this honorable court's order. Your lordship be taken up, my lord, it will be disposed.
Take up tomorrow.
Tomorrow, your lordship.
And if it is not taken up, you will make a mention.
My lord, it will. My lord.
At 2, you can make a mention, but ensure that other
Union of India is there. Council. I will.
Madam, item number 45. I filed a rejoinder to the counter filed by the restaurant. And actually is up to today because on the last one, it will come to me.
It will come tomorrow.
45.
And if it is not taken up, please make up. Yes. Yes, sir.
No, lordship, a little. Lordship.
You can meet me in my chamber.
Lordship, grateful, lordship.
No.
Truly, lordship. Truly.
Yes.
48, may I pray for next week? 48.
Yes. No, you mentioned 32 and then 48. And then you will mention.
It may be taken up in the orders. There is an I.
Item number 47 and 51 can be taken up next week. Great.
51 maybe
Next week.
next week. Next week.